Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
That him he Anglican boy, he's very sloppy.
Is that correct?
I didn't ask you to interrupt me. Oh, for God's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you here this morning. Hope you all are doing absolutely fantastic on this Friday. I would say it's a no-pants Friday, but it is freezing. It's freezing cold. And apparently all the snow is coming to my house this weekend. So there's that as well. So yes, I made an exception. I'm wearing pants today and hope to stay warm.
I'm trying to have 4 great boys.
All right, a big shout out to Francis Fitzgerald, who was first in chat this morning. And Francis Fitzgerald, being first in chat comes with its prizes, but it also comes with its punishment. We're focused on the punishment for you. Everything IP related worldwide is your responsibility until we go live again. The internet is all yours, my friend. Good luck and good riddance. All right, we're a little bit behind. We've got court doing some of the busy work before the jury comes in, and I want to hear it because it's getting good. It's getting good, so we had to start early. And I apologize, I'm a little bit late, but set up the grill Wisconsin style in the snow. You know the story about me and grills, right? Every time I set up a grill, a world catastrophe happens, like COVID. Like if I go buy a new grill, COVID will strike again. I kid you not. The timing is like, I don't know why. I don't know why it's connected, because I like grilling, and I don't like having an old grill. But I can't replace the one I've got because, World War III. Anyway, welcome. Yes, the little areas get their snow wish to the tune of 12 to 15 inches. We have never seen more than about an inch here since I moved here in 6 years. And 12 to 15. Sounds great, huh? Yeah, not excited. I do not own a shovel. I do not own a snow shovel. So we just aren't going to go anywhere for about a week. All right, we have to sing happy birthday really quickly. Yeah, they say 12 to 15. That's on the upper end. It could be lower, but we've got 4 gallons of milk left, which will last us 2 days, and 3D printed shovel. Let's do the birthdays, because we have to get to court really quickly so we can get caught up and watch the proceedings today. So we're going to sing happy birthday to Amanda C., Cody Height, Jim, and Robin. Everyone stand up wherever you are. Deep breath, shoulders back. Project your voice to the back of the room.
Birthday.
Blend your voice with the neighbor and warm up with me if you will. La 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 la. Got it. Found it. We're ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Amanda C., Cody Height, Jim, and Robin. Happy birthday to you. Amanda C., Cody Height, Jim, and Robin. There are many wonderful days, but today of all days is your special day. I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully you can turn that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. First time. As the music continues, the dancers are doing their thing. I will remind you, we did a poll yesterday on guilt and innocence, and 90% of us leaned towards guilty. Yes, the state had proven the elements of the charges, which we will hear this morning. Love this interlude. Amanda C., Cody Height, Jim, and Robin, happy birthday. Thank you for letting us celebrate your birthday with you. And thanks for being here to celebrate with us. So, it's all good. I feel like we've got like an extra verse today. That's good. Boom, 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 boom. Have you pulled the audio file? Yes, I have. Yes, I have. We've got it ready. Got it ready. Big shout out to Court TV. You had the best copy. Drum solo for the big finish. Here we go. Before we go to court and catch up on what the stuff they're doing without the jury there, I want to play you a little bit of audio and shout out Court TV for this. Let's get right here to my editor and let me show you what we have been doing overnight. I fell asleep in my chair here last night doing this, so finished it up this morning. We grabbed the audio from the 911 call, particularly the 911 call where they hung up, the first 911 call. And I want to play that for you right now. So let's give it a quick little listen. Let's see if I can use this command. Oops. Emojis. That's always nice. Not what I need, though. No, I'll say no to emojis and just go down here and play. How about that? There we go.
February 24, 2023.
Gets louder here.
7:47:32.
Fairfax County 911, where's your emergency? Hello, Fairfax County 911.
February 24, 2023. 7:47:39.
So it just lasted a few seconds. That call is the one that has both the sound they say is the dog, the moaning, as well as the sound they say is voices in the background. And I did a little work on it. I'm going to play it like 6 different times, sort of in rapid succession here. Here's just the isolated part where I heard the voice before they talked.
Fairfax County 911, where's your emergency?
And now I'm going to play it over and over with varying degrees of voice isolation.
Hello, Fairfax County 911. Fairfax County 911, where's your emergency? Hello, Fairfax County 911. Fairfax County 911, where's your emergency? Hello, Fairfax County 911. Fairfax County 911, where's your emergency?
They're very subtle changes
Hello,
on these.
Fairfax County 911.
2 more.
Fairfax County 911, where's your emergency? Hello, Fairfax County 911. Fairfax County 911, where's your emergency?
Interesting.
Hello, Fairfax County 911.
As I slowly turned up the adjustment to limit sounds that the computer says were probably not voices or not dialogue, it eliminated the moaning. It doesn't mean it wasn't a human. It just could tell that it was not dialogue. Now, we've got a little bit more to listen to. I've isolated just that voice over and over so we can listen to that. And you tell me what you hear here. But this is the cleanest.
Fairfax County 911, where's your emergency? Hello, Fairfax County 911.
All I can tell you is it sounds like, to me, I hear I can't have ends in S, but it doesn't make sense. That literally I've listened 1,000 times. Can't have heads, can't have heads, can't have heads. I have no idea what it's saying. It is a voice. Now I listened to that voice and I thought, what voice would it be? And I went to this part of the later call. This is where they're trying to get the address from Juliana on the third 911 call. The second one.
They can give me the address.
13230 Stablebrook Way.
Okay. And what's your name and what's going on?
My name is Brendan Banfield. I'm a federal agent. This is my house. There's somebody here. I shot him. But he stabbed her.
He obviously is not saying the same thing during that call where he's talking to the 911 agent that was said in the call, but I think it was a man's voice. It doesn't stand to reason that it was Joe, and I can only conclude that that voice is something that Brendan was saying. So that's the best I could do for you guys. We have to jump to court because they have started already, and we want to catch up on what we've missed on. So hold tight for just 1 second as they're coming in, and we're going to join them and hear some of the stuff that's sorted before the jury shows up.
Good morning, Carol. Please be seated and come to order. All right. Good morning.
Good morning, Judge. How are you?
Good. Morning. I don't know how am I guess is the question.
I think we're good.
Okay.
Your Honor, the Commonwealth has elected to proceed on 1 count of aggravated within 2 within 3 years and 1 count of aggravated same transaction. We have presented 1 instruction for each of those counts. It is the model. Perfect. We have added to that 1 instruction that had not been previously provided for child endangerment. We will not be going forward on.
And I'm going to take out the child abuse one.
Abuse and neglect, exactly.
Okay.
And then we have withdrawn, and I can tell you which letters.
Okay.
Instructions that were related to first degree, second degree.
Let me hold on a moment, just for the record. Which counts of the 4 counts of aggravated murder are you going forward on?
That was the judge's suggestion.
Either 1 and 3 or 2 and 4. I think those are the options.
Right.
But I just want to make sure for the record. Sorry.
And I'm sure you're right, Judge, but we'll open it really quick and just make sure that
absolutely.
Our 1 and 3 and 2 and 4 are the same as yours.
So we're gonna listen through this and then catch up with when the jury arrives. This is outside the presence of the jury. The state just elected to do exactly what the judge suggested yesterday. They're like, no, Judge, this is the way we do it. They just followed the judge's recommendation. We've got 1 of each of the 2 charges because aggravated murder can only occur it only applies if there were 2 murders that took place based on this qualifier. So it's
sure.
So
1 and 3?
1 and no. 1 and 4.
1 and 4.
1 and 4?
1 and 4.
Okay, absolutely, that's fine. Any objection to that then?
No, you aren't.
All right, so we're going forward on count 1 and 4 of the case number ending in 666. And then for 2 and 3, there's a motion to dismiss those.
Oh, wait, okay, hold on, I'm getting tapped.
No, ma'am.
Wait a minute, hold on. There seems to be a change here.
Sorry, we're gonna read this one more time.
Same after transaction.
Yep.
1.
1.
For Ryan.
Okay. And then
4. Same 3-year period, Christine. Yes. 1 and 4. Dismiss 2 and 3.
Okay.
Yes.
Final answer?
Yes.
Okay. 1 and 4. So we're dismissing 2 and 3 with no objection. Okay?
No objection.
All right. So 1, 4, and 5 under the case number 666, and then we just have child endangerment on
Which
the
is
one ending in 873. Okay.
count 1, Judge.
That is count 1.
Yes.
The jury
So
will
count
hear
2
the
is
911
dismissed.
call,
Yes,
but
ma'am.
not my
On
version.
873. Okay, fabulous. So now I have the ones before that we had talked about. Do you just want to go through those?
Yes, ma'am.
Okay.
And I will pass up our new stack. They're clean. They have the
Okay,
letters typed
excellent.
in.
All right, so I had
I like a clean
instruction
stack.
A, which I assume is still the same, correct?
Yes, ma'am.
Okay, and then we'll withdraw instruction B since he did
Correct.
testify? Okay, withdrawn. And then you still have C?
Yes.
Okay. D?
Yes.
E?
Yes.
F?
Yes.
G?
If they stop sticking together, yes.
All right, and then H?
Judge, I have an I next.
Oh, I'm sorry, H is child abuse, so you're throwing that one.
So that would be withdrawn.
Okay, fabulous. All right. And then we have I.
Yes.
Okay. Q.
So Judge Q would be withdrawn?
Q is withdrawn, I assume without objection?
Without objection.
Okay, Q is withdrawn. Okay, what do you have next? R?
I actually had an L.
Okay, you had L. I switched them around a little bit because...
That's okay, because they didn't make sense in that order. That's fine.
Well, not to me, but...
Nope, that's A-okay, I can track. So
that's fine, I'll just...
If you're on R next, we would withdraw R.
Selena, thanks for the 5
okay.
gifted memberships.
We would withdraw S.
I have M next.
Okay,
M
so
is in Mike.
M is in.
Okay.
These are the
S
jury
as in Sam.
instructions.
S as in Sam would be withdrawn.
Okay.
Mary Tedeschi gifted a membership
N
as
as in
well.
Nancy.
Thank you.
Yes.
O.
Yes.
P.
Yes.
T. As in Tango.
Yes.
Takes 2.
And then I think, let me see, then I have some of his instructions. I think that's all I had for you. So which ones would you like to add to that?
So I have L, which was willful.
Willful, okay, you have L.
I do.
All right, do you have a copy?
I
Well,
do.
You got the clean copies,
Yep,
that's
I'm
fine.
gonna
Okay,
pass
so
that up to Your Honor.
we'll add L, okay, and what else?
And then I have U, which is the instruction for aggravated murder, 3-year period.
Okay,
And then I have V, which is the instruction, aggravated murder, same act or transaction.
okay.
And then I have X, which is the crime of child endangerment.
Child endangerment, okay. And your U and B have the waterfalls also?
They do not, Judge.
You're not doing
We are not
waterfalls.
doing a waterfall.
You are just standing on aggravated murder?
We are.
Okay.
Don't
that
go
is your
chasing
option.
waterfalls. There you
Do
go.
you want waterfall instructions, Mr. Carroll?
No, Your Honor.
No.
I'm gonna stand on this as well.
Okay, so we're standing on aggravated murder. You've just made life a lot simpler for me on your decisions, but that is your decision. Okay, so no waterfalls, we're standing on aggravated murder.
Yes, and I'm passing them up with the previously agreed upon new separate so that you can put them in as you
Okay.
would like them to appear.
All right.
I also understand we've agreed to defense 2, 4, 10, 12, 16, 20, and 36.
I think that's what I have.
No
Let me make
changes.
Sure. That's the only, those are the only ones I had already had, correct?
Correct.
Yes, Your Honor.
I have 2, oh, I do have L, okay, sorry. I do have 2, 4, 10, 12, and 16, and 20, and 36.
Yes, ma'am.
Okay, anything to add to those, or that's it?
No, Your Honor.
Oh, you guys get a gold star today.
Thank you.
Okay, that is fabulous. All right, so you want to hand me up the, you have the clean copies for your, oh, you already gave me.
Yep.
Okay, I got the clean copies. And do those include Mr. Carroll's, or Mr. Carroll, yours were already clean copied, correct?
The ones that I handed up before were clean copies.
Okay, so I can just insert his into
Yes, ma'am.
yours. Perfect.
And
I
at this
can do
point,
that.
we owe you a verdict form. Now that you have accepted those
Right,
instructions.
yes, I have those instructions.
We will provide you with a verdict form.
Okay, oh, that's fine. So if you want to provide a verdict form, I can have Shannon do one since it's just aggravated murder now. It's not too difficult.
If
I can do that.
That's just fine.
So we'll do 3 verdict forms, 1 for aggravated murder, 1 for firearm, and 1 for child endangerment.
Yes,
We're on
ma'am.
the same sheet, music? Okay, good. 3 verdict forms?
Ms. Frisler is asking, do you think we need 2 aggravated murder forms?
Oh, yes,
given
I'm
that
sorry.
there are
I
2 separate?
apologize, you're right, because you did go ahead and do both, same occurrence and 3 years.
And 3
Yes,
years.
so we need 4 verdict forms. Aggravated murder in the same act and transaction, aggravated murder in 3 years, firearm, use of firearm, and child endangerment. Okay, we'll get those together.
Perfect, thank you.
And by the end of closings, we'll be able, you can review them before they go back to the jury.
Great, thank you.
Okay.
Evangeline White, thank you for
Your Honor,
33 months.
Is there an order that you're going to be calling out the jury instructions?
Oh, gee.
There is. Let me just put it back into the order, and I will let you know. And I will actually get copies to you as well.
Okay.
In the order that I'm going to give them, and I'll get one for the court reporter too, Carol.
Great, thank you.
So I'll do that. We'll have time to do that, okay?
Okay.
So that takes care of jury instructions. Do I have Ms. Smith here yet? Ms. Smith, are you here? Are you ready for your motion?
Yes.
Let's go. Is that okay?
Yes,
I'd
absolutely.
rather do that than I can go back and put those instructions all
Yes,
in
ma'am.
order. Ms. Smith, you can just come to the center podium. That's fine.
Thank you.
Apologize. These were all withdrawn.
Just want to make sure I have the right Miss Smith. This is for the access motion?
Yes.
Okay, great.
Well, you're Miss Smith, so.
Well, no, I know.
This is media.
There could be
This is
multiple Miss
media.
Smiths, so I wanted to make
Well,
sure.
the odds were pretty good that that I had the right person. I know it was set for 9:30, but since since we were so organized today, if it's okay with you, I'd like to go ahead and do it now.
Absolutely.
All right. I've read your motion,
Thank you.
so you don't need to regurgitate it, but anything you want to add to the record, you're welcome to.
Oh, thank you. No, I mean, I appreciate you reading it. And just for the record, I'm Alia Smith here on behalf of ABC and NBC for access to sealed records. And I won't repeat what's in our papers other than to say I read the Commonwealth's opposition yesterday.
Right.
And, I don't think that they offered the compelling reasons that are necessary to seal, in a public criminal trial.
This is big.
The fact that the litigation was concluded in the Daily Press case, which is one of the main authorities that we relied on, I don't think is a distinction, because the harm that they're claiming here is not to do with jury tampering or jury impact. And same with they try and distinguish the press enterprises cases, because in the press enterprise cases, the Supreme Court was dealing with the sealing of a whole entire trial.
Being closed, correct.
Correct, and that's
show.
true.
Thank you.
And I
OG
appreciate
jury.
very much that most of this trial has
Law
been
warrants
completely
are
open.
400 exhibits and televised. So.
Exactly, and the exhibits available on the internet. But I think the point of the press enterprise and Globe newspapers and all the Supreme Court cases is that every aspect of a criminal trial needs to be open, and if it's not, the sealing has to be justified by on-the-record findings of a compelling interest, and I don't think that's
the
been
law.
done here.
Okay.
That's
All
the
right.
law.
Thank you, ma'am. Did you want to respond? I did read your opposition brief.
We would submit on our brief.
Submit on your brief. Did you want us to respond, Mr. Kerr? You join your microphone, just.
Your Honor, I would join in the Commonwealth's position.
All right, thank
they're
you.
both
Okay,
opposed
you can
to
stay right there.
unsealing.
That's fine. All right, so the ruling on the media motion, non-parties ABC and Dateline have moved to unseal certain exhibits admitted during this trial. The court fully recognizes and respects the First Amendment and the fundamental principles of transparency in our judicial system. These proceedings have at all times been open to the public and the media has not been denied access to any hearing or trial testimony in this case. At the same time, the court does not take the sealing of documents lightly. When considering sealing or unsealing, the court must balance the public's right of access against other compelling constitutional and statutory interests. Here, the constitutional and statutory rights of crime victims. Article 1, Section 8 of the Virginia Constitution, entitled Rights of Victims of Crimes, and Code 19.2-11.01, entitled Crime Victim and Witness Rights, require that crime victims be treated with dignity, respect, and sensitivity, and that their privacy be protected to the extent permissible under law. Victims are defined in relevant part to include family members of homicide victims, including spouses, parents, children, and siblings. As the Supreme Court recognized in Globe Newspaper Company versus Superior Court, the First Amendment right of access to criminal trials serves the important purpose of protecting the free discussion of governmental affairs. However, that right is not absolute. It may be limited where there is a compelling governmental interest, and any limitation must be narrowly tailored to serve that interest. The court finds that unsealing these materials would add little, if anything, to the public's understanding of the judicial process, while substantially infringing upon victims' constitutional and statutory rights. Here, the court finds that the protection of victims' rights constitutes a compelling governmental interest. That interest necessarily limits the public dissemination of graphic depictions of deceased victims, nude victims undergoing life-saving measures, and autopsy images, particularly where such materials would be available for permanent public distribution, download, and reproduction worldwide. The First Amendment does not require the court to permit the exploitation of crime victims or their families by releasing graphic images of their loved ones' bodies for purposes unrelated to public oversight of the judicial process. The victims in this case were a mother, daughter, sister, and a son, brother, and grandson. Their surviving family members' constitutional rights must be considered and respected. This remains a public trial. Of the exhibits admitted into evidence, approximately 400 exhibits are unsealed and publicly accessible on the court's website 24 hours a day. 74 exhibits were placed under seal. The court has reviewed each sealed exhibit admitted in this case to ensure that sealing was narrowly tailored and justified. I will note initially that one category of material referenced in the motion, the co-defendants' interviews with the Commonwealth, were never admitted into evidence and are not part of the court's record in this trial or any pretrial proceeding. Okay, those materials remain in the possession of the parties and are not subject to unsealing by the court. Additionally, the minor child's interview was sealed pursuant to a pretrial motion due to the presence of a minor victim, and that sealing remains appropriate. With respect to the sealed body-worn camera recordings, the moving parties requested that the court redact or excise portions depicting victims' bodies and release the remainder. The court received these exhibits in their entirety as evidence. It is not within the court's role or technical ability to edit, splice, or alter admitted evidence, and the exhibits must be considered as they are entered into the record. All sealed exhibits were sealed pursuant to motions agreed to by the parties at the time of admission. For the record, the court will now go through each sealed exhibit and state the basis for sealing. In doing so, the court does find that certain sealed exhibits do not implicate victims' rights and therefore will be unsealed. Okay? So I'll go through it. I'll give you a copy of this.
No, and I appreciate that. And can I just be heard on for one moment on the body-worn camera footage?
You can, but I'm not going to change my mind. Okay. All right. So would you not rather do? Okay, good. Okay. So let's go through the sealed exhibits. All right. Number 4 is a body cam of Officer Hugh. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. A recently sealed number 5 is a picture in the far right corner. You can see Mr. Ryan's body. Number 6. Of the Commonwealth's evidence, body cam of Officer Beckner. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Number 8 is a photo from the still body cam, and it's of the victim's body. Number 9 is also a photo from the body cam of the victim's body. Number 10, the body cam of Officer Gibbons. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Commonwealth's Exhibit 11, the autopsy report, will be unsealed. Commonwealth's Exhibit 12, the autopsy report of Mr. Ryan, will be unsealed.
Amanda H., thank you
Number
so
11
much.
was Ms. Banfield. Number 13 is a photo of Joseph Ryan's deceased. Number 15 is a photo of Joseph Ryan deceased. Number 20 is a photo of Joseph Ryan deceased. 22 is a photo of an autopsy of Ms. Banfield. 23, 24, 25, 27, 28, 29, 30, 31, 32, and 33, and 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, and 49 are all photos of the autopsy of Ms. Banfield. Number 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, and 71, and 72 are all FetLife conversations which will be unsealed.
Boom. Those are spicy.
Number 98 is a photo, aerial view of the house, but Mr. Ryan's body is in the photo. Number 9, a photo of Mr. Ryan's body on the floor. 100 is a photo of closer up of Mr. Ryan's body on the floor. 101 is also Mr. Ryan's body. 101A is that same photo with annotations. 101B is the same photo with annotations. 123 is a photo of Joseph Ryan's body. 123A is the same picture with annotations. 123B is the same picture with annotations. 124 is also a photo of Joseph Ryan's body. 170A is a photo of 171 with annotations, which is a picture of Joseph Ryan on the floor, deceased. 172 is a photo of Joseph Ryan's as well on the floor. 174A is that same photo with annotations. 181 is a photo of Joseph Ryan's body. 221 photo is of Joseph Ryan's body. 221A is the same photo with annotations. 241 is a photo of the body-worn camera, a still photo with the victim, Mr. Ryan, on the carpet at the crime scene. As far as defense sealed exhibits, the body cam video of Officer Palmer has the body of both Joseph Ryan and life-saving measures being taken from Ms. Banfield at the crime scene. And number 87 is a body cam video of Officer Casanova without audio, and the minor child victim is present for a significant portion of the video. And 119 is a Gmail log for FetLife, which I will unseal. So I will give you a copy of those, and I'll highlight the ones that I'm unsealing. They're already highlighted.
I appreciate that very much. And just for the record, I'd like to add that in the Knorr case that we cited, the court did order the availability of redacted video and documentary records. And in the AP case from the Fourth Circuit, the court held that administrative burdens are not a sufficient compelling reason to keep things. And so I really feel like, there's a way that public can have access to some of this, even if they don't have the specific, very graphic images.
And the exhibit is the exhibit, and I take the exhibit as it is. All right. Thank you very much for your motion, and have a good day, Ms.
They're going to peel that one.
All right. Do we have anything then until 10 o'clock?
No, ma'am.
All right. I will go ahead and get the instructions put together in the order I'm going to do them, get a copy of them, and if you want to stay here, I'll get you the copies so you can be prepared for your opening statements, okay?
Thank you.
All right, thank you.
All rise.
All right, so the press, they want everything. Obviously, they asked for everything that was sealed to be unsealed, including, I mean, literally everything. All the autopsy photos, the crime scene photos, the body cam video. It plays better on TV. It gives you something to look at when they're and obviously there's some things they wouldn't show. Hopefully, I mean, most even graphic TV shows have a limit to how much gore they would put on the screen. But there's some things they would, and it definitely would definitely make the victims uncomfortable. And victims, the definition of Virginia law includes the survivors, the descendants. So the media motion, for the most part, failed. The only thing they got were documents, and they're documents related to FetLife, whether it's Gmail or FetLife conversations. So those are probably the spiciest documents in the trial as far as content, because it's them lining up what they want to have happen. So that will be released, and everything else will not. And even though the media attorney argued, even at the end, she's like, hey, she said she wasn't going to argue, right? The judge says, you can argue this about my decision about the body cam, because they wanted the courts to redact it and then release it. And she's like, we're not set up to do that. We're not video editors, so we're not, it's an exhibit. And she argued and said, case law says the fact that you're not set up to do that is not an excuse. You should redact them and release them. So they might win that on appeal and get redacted body cam footage. But I'm not sure. That'll be way down the road if that happens. So they can chase that up the legal chain. All right, we have big break. For those that missed it this morning, we did have a little session listening into the audio from the 911 call. That there's a voice heard. There's what I would say is a male voice heard speaking, and not in a strained or urgent or a frantic tone, that's picked up briefly on the 911 call before you have that 1.4 seconds of a dog or a person moaning. And we listened to that a couple times. If you want to catch it, it's on the replay right after the birthday song. Right before we went to this session, but I couldn't make anything out of it. I'll play it really briefly just once more for you guys while we get set. Let me see if I can. And shout out to Court TV for having the best version of this that I could find online. Let's see, where's my keyboard? I'll just use this one.
Fairfax County 911, where's your emergency?
Hello,
Fairfax
over and
County
over.
911.
Interesting. I couldn't make anything of it. I would say it does definitely sound like a voice, but not sure what it. Yeah, it's before the sound, whatever that is. That sounds like 3 syllables or three different words. All right, we have closing arguments coming up in just mere minutes. The jury's assembling as we speak in the courthouse up in Fairfax County, Virginia. Closing arguments will be headed our way, and then this could be in deliberation. Maybe lunchtime. It's going a little faster. I didn't realize they were going to start quite as early as they did. So with all the jury instructions out of the way, that's going to be finalized. The media motion has been documented and set in stone. So everything's going to be pretty much stayed sealed that was sealed before, all the photos and video. Then just going forward, we're just waiting for the jury instructions to be read to the jury, the closing arguments, and deliberation. So we'll be in deliberation probably this afternoon. Francis Fitzgerald, member for 19 months and our internet owner today. Hubby and I are flying tonight to Arizona. We get there safely. Cross your fingers. Thank you, RA and mods, for making this a great place to hang out and watch court. Thank you, Francis Fitzgerald. Appreciate it. 19 months. That's amazing. Didn't sound like a dog for sure. Yeah, it didn't. Sounds like the phone drawer. What did I grab? I think I grabbed the recording the defense expert made. Let me do a quick. Let's go back to the editor for a second and play around for a second, as we have just a moment before court starts. Let's import. From Big Deal. That's why I name my drives Big Deal. I think we've got like, it's going to be yesterday. 255. No, I think it's this guy. I think it's that one. Moving it over the network, and it's already here. It's this one right here. Okay, let's give a little play to this. This was the defense. Go back right here. There we go. This was the defense playing the audio from their expert, and they needed help from the tech support to do this. We'll see if we can get it to play properly.
Sir, could you hear that?
No.
Not really well, but I could.
Okay, sorry. Let's rewind a little bit. Gonna play it again.
Am I good to go? Okay.
It's just not.
Okay, they're going to play a little better copy here in a minute when they bend the microphone down and play it again. Listen right here. This is the sound they say was Lily 3. The first part is Lily, and then you're going to hear that sound that we heard after the in the 911 recording. Clearly a crossfade.
Sir, could you hear that?
That was so bad.
Not really well, but I could.
Is there another way to hook into the system?
She'll play it one more time. All she does is turn the volume up. We'll try turning it up. That was so bad. Anyway, we talked about that yesterday. What that actually was the two recordings. The first one from from the Lily tape, which we have not heard isolated. We didn't get to hear the dog by itself, where they took about 4 or 5 seconds of Lily howling outside or moaning, whatever they call the dog, the husky making noise, wanting to get inside. Recorded that and matched it up by sort of overlapping so that the two happen at the same time, and the sound of Lily gets turned down slowly while the sound of whatever's on the 911 call gets turned up slowly, and the effect is that it merges the two together seamlessly. It makes it is a transition. It's a gradual transition that makes it happen, and it makes it sound like, yeah, that's a match. It's the dog just changing pitch, when in actuality, if you play them back to back, you've got the dog up here and then the person over there, and it's very abrupt. They didn't play that for court that way. So anyway, let's see. Anything else we need to follow? Probably not. I think we're just gonna go to court and wait for them to start, which should happen any second now. Is there anything else we need to? I can't remember. Is there anything I'm missing? Feels like I forgot something. But it's good to get the replay machine out and put it to work again this morning. It's been a few days since we've used that. Let's see. Had McDonald's yesterday. Did I tell you? All that advertising pays off. You will bring the jury. All right. We'll get sorted here in just a second. All right. Yes. Who else wants McDonald's after hearing about it all day in chat? Camila, I haven't opened them yet. I've just been super, super busy. I did get them. I just haven't opened them. I spent also yesterday after work. I spent 2.5 hours out in the Airbnb. I was standing on a ladder, but my son, my ninja son, was weaseling through an extremely tight and very nail infested. It's so many nails up there. Attic above our Airbnb, insulating pipes against the cold that we have coming. We had them freeze briefly, no problems, no leaks, but we had to
taking care of it. We got your clean parts now, and then you had the 20 that you wanted to put the two together. Which, if you want to take a look at it,
yes.
If you want to approach,
yes, ma'am.
You wanted to add 20, but you had two 20s. So we combined them, Shannon combined them for you. Is that?
Yeah.
And there's no objection to 20?
No, ma'am.
All right. So what we'll do, no problem. So what we'll do, this is the order. I'm going to read them in for the record, and we have copies for the attorneys and for the court reporter for right now. Then we'll get copies for the jurors as well. All right, so the jury instructions we read: instruction A, C, D, E, U, V as in Victor, L, I, M, F, G, X, N, O, P, T, 2, 4, 10, 12, 16, 36, and 20. Okay? All right. Is there anything else before we bring the jury out?
No, ma'am.
Okay. Okay.
bring the jury.
Okay. I think this thing is on.
Hear the printer going in the background as they frantically print out jury instructions at the last minute.
Good morning, ladies and gentlemen. Swear juror number 2, I'm going to have to put you on the payroll. You keep that door open every time you come back. I really appreciate it.
Nice.
All right,
nice
ladies
juror.
and gentlemen of the jury, you now have heard all the evidence in this case. All right, before the lawyers make their closing arguments, the court will give you the instructions of the law that you are to apply in deciding this case. Since it has been quite a while since I gave you the preliminary instructions. I want to remind you that in their closing arguments, the lawyers will refer to the testimony and other evidence that you will have heard, but what the lawyers say in their closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as 12 jurors of what the evidence in this case was, which shall govern your deliberations. In addition, remember your notes should be used only as an aid to your memory. You should not give your notes precedence over your independent recollection of the evidence, and you should rely on your independent recollection of what the evidence in the case was, and you should not be unduly influenced by the notes of other jurors. In addition, a reminder that the court has sealed the names of the jurors for a year. Just wanted to make sure I remind you of that.
For 1 year.
As far as the jury instructions are involved, you'll be able to take these written jury instructions into the jury room with you, and it will make copies for all 12 jurors, okay? So you don't need to take notes on them right now, but I would ask for your attention when I read them, okay? With respect to the instructions I'm about to give, you might notice that at the top of them, some of them are numbered and some of them are lettered. You not have to concern yourself with that. You're just looking at the body of the instruction themselves, okay? Some of the instructions may appear to be in conflict. This is because the court cannot predict your findings of fact. Therefore, the court must instruct you, the jury, on the applicable law under both the Commonwealth's case and the defendant's theory of the case, okay? Brendan Banfield is presumed to be innocent. You should not assume that he is guilty because he has been charged and is on trial. This presumption of innocence remains with him throughout the trial and is enough to require you to find him not guilty unless and until the Commonwealth proves each and every element of the crime beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for a conviction. There is no burden on Brendan Banfield to produce any evidence. A reasonable doubt is a doubt based on your sound judgment after a full and impartial consideration of all the evidence in the case. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. You may convict Brendan Banfield on circumstantial evidence alone, or on circumstantial evidence combined with other evidence if you believe from all the evidence that he is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any has been shown, their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. You may not arbitrarily disregard believable testimony of a witness. However, after you've considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may decide which witnesses are more believable and weigh their testimony accordingly. If you believe from the evidence that a witness other than Brendan Banfield previously made a statement inconsistent with his testimony at this trial, the only purpose for which that statement may be considered by you is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred within a 3-year period. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred as part of the same act or transaction. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. Willful, deliberate, and premeditated means a specific intent to kill adopted at some time before the killing, but which need not exist for any particular length of time. A willful act is one done with a bad purpose or without justifiable excuse, or without ground for believing it is lawful. A willful act is intentional, or knowing or voluntary as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that the particular conduct will likely result in injury or illegality. To prove the charge of murder, the Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Brendan Banfield is charged with the crime of using a firearm while committing or attempting to commit murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that Brendan Banfield used a firearm. And number two, that the use occurred while Brendan Banfield was committing or attempting to commit murder. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find Brendan Banfield guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. A firearm is any instrument that is capable of expelling a projectile by force or gunpowder. A firearm is also an object that is not capable of expelling a projectile by force or gunpowder, but gives the appearance of being able to do so. The existence of a firearm may be proved by circumstantial evidence, direct evidence, or both. Brendan Banfield is charged with the crime of child endangerment. The Commonwealth must prove beyond a reasonable doubt the following elements of that crime. Number one, that Brendan Banfield had custody of Valerie Banfield, who was a child under the age of 18. And number two, that he willfully or negligently caused or permitted the life of such child to be endangered. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt both of the above elements of the crime as charged, then you shall find Brendan Banfield guilty of child endangerment. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. The fact that Brendan Banfield has been indicted by a grand jury is not evidence against him, and you should not consider it. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participated in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be discarded. You may infer that every person intends the natural and probable consequences of his acts. The Commonwealth bears the burden of proving beyond a reasonable doubt the identity of the defendant as the person who committed the crimes charged. If the Commonwealth has not met this burden, you must find the defendant not guilty. You may consider the character of the defendant when proven by the evidence, whether good or bad, along with the other factors and circumstances in the case in determining his guilt or innocence. The statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. If you believe from the evidence that the defendant previously made a statement inconsistent with his testimony at this trial, that previous statement may be considered by you as proof that what the defendant previously said is true. Juliana Perez Magales has testified that she was an accomplice in the commission of the crime charged in the indictment. While you may find your verdict upon her uncorroborated testimony, you should consider such testimony with great care, and you are cautioned as to the danger of convicting the defendant upon the uncorroborated testimony of an accomplice. Nevertheless, if you are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt, the defendant may be convicted upon the uncorroborated evidence of an accomplice. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe that the defendant reasonably feared under the circumstances that they appeared to him, that he or others were in danger of being killed or that he or others were in danger of great bodily harm, then the killing was in self-defense and you should find the defendant not guilty. The defendant contends that he acted in defense of another person. Under Virginia law, this defense is governed by the same principles that apply to self-defense. Number one, burden of proof. If the evidence raises a reasonable doubt as to whether the defendant acted in lawful defense of another, the jury must find him not guilty. Number two, reasonable belief of imminent danger. The defendant must have had a reasonable belief that the person he sought to protect was in imminent danger of bodily harm. All right, closing arguments.
Thank you, Your Honor.
Here we go. I'm not aware of any time limits on these.
And if we can have the display for the jury activated from our table, and it does include sealed exhibits, so we'd ask it not be displayed to the gallery.
Just to the jury and not to the gallery.
Thank you.
Yes, ma'am.
Pretty sure the gallery can see some of what the jury sees.
Okay. Good morning. Thank you so much, not just for what you're going to do today, but for all of the time that you have spent carefully considering the evidence that we've been able to put before you, for the attention that you've paid, for the notes that you've taken, for the time that you've given up away from your daily lives, your jobs, and your families. Without your work here, Christine Banfield and Joseph Ryan would not be able to find justice. So thank you. The judge has read the instructions to you. They'll go back to the jury room with you, and you're going to have those as your guide in making your decision. I would draw your attention to the fact that you've been given 2 counts of aggravated murder, 1 count of use of a firearm in commission of murder, and 1 count of child endangerment.
That's not correct.
Talking first about the aggravated murder instructions. They have 3 parts. You'll first need to find that Brendan Banfield killed Christine Banfield and Joseph Ryan. You'll need to find that those killings were willful, deliberate, and premeditated. You'll need to find for one of the counts that those 2 murders occurred within a 3-year period, and for the other count, that those 2 murders occurred within the same transaction or occurrence. We know that they were killed during the same event within the Banfield residence, so that should knock that one out for you. 3 years, pretty simple as well. We know that they occurred on the same day. It's the first element that we're going to talk about, that Brendan Banfield killed both Christine Banfield and Joseph Ryan. We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. But you've heard directly from our detectives and our experts the uncontradicted evidence of Brendan Banfield's culpability. You needn't rely only on Juliana's story. There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhaes are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history, none, of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. Brendan told you that more than 10 years ago, there were incidents of affairs involving rough sex. But you have 0 evidence to corroborate that self-serving statement. Think about the 2 days of Mr. Lidsky's testimony for the defense and the 3 times that Detective Miller was called to this stand. If there was one scintilla of evidence that supported these claims of infidelity, of interest in sexual violence, don't you think you might have heard about it? The FetLife and Telegram contacts all occur on Christine's laptop, frequently while her phone is in use with something completely innocuous. You remember the frozen tickets, the Lululemon shopping, the family vacations the day before the murder? 2 devices, 2 different people. The FetLife and Telegram usage only ever occurred when Brendan Banfield and Juliana Perez Magalhaes are in the home. Is it at all plausible that this woman wouldn't take advantage of an empty house to engage in her plans for adultery? That on the 2 weekends that her husband and the nanny are out of the house, those are the 2 weekends where we see 0 FetLife activity, 0 Telegram activity? Let's look at the chats themselves. Slide 1. How many potential targets were turned down by Juliana and Brendan because they wanted to meet in person first? Because they wanted to talk on the phone? Because they wanted pictures that included Christine's face? Does this make any sense for someone seeking a new relationship in a area of sexual exploration that would be new to them? Why would the real Christine Banfield have been concerned about taking these safety precautions? For that matter, why would the real Christine Banfield have been searching for someone who was willing to engage in knife play when she had a blood clotting disorder? Why would Christine use a phone from a gym bathroom, sorry, a photo from a phone taken in a gym bathroom when she has all of these far better pictures available? That one keeps stumping us. There are so many more whys, and I'm sure you have plenty of them in your own heads, but the answer is the same to all of these whys, because it wasn't Christine, it was Brendan Banfield with the help of Juliana. Let's talk about our physical evidence. You heard from Detective Leach, Dr. Kessler, Ms. McCarthy, Dr. Greenspoon, Ms. Colombo. She was up there forever with all those lab sheets. They gave us a million things to think about. Slide 4. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. Next, the knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. This was not the killing knife that Brendan Banfield had envisioned for his scheme. Next, Joe Ryan was shot twice. Once in the head by Brendan Banfield, incapacitating him. A second time by Juliana in the chest, tearing a large hole through his heart and lodging in his spine. His wounds were rapidly fatal, according to Dr. Kessler, and we saw that there was little to no blood from the chest wound. Iris Daly-Graf told you that he would have been incapable of movement following that second shot. Next. We saw evidentiary confirmation of the affair. The semen stains on Juliana's bed sheets. We also saw the photos of Juliana's clothing moved into the primary bedroom when the search warrant was executed in October following the murders. We saw the photos of Brendan and Juliana together, both before and after the murders. Her photos from her Instagram, their family photos in the bedroom after the murder. We saw the records from the shooting range for the purchase of the gun and the training of Juliana to shoot it. Slide 8. We saw the deactivation of the automatic locking feature on the front door at 5:47 a.m. the morning of the murders, done from Christine's phone by the person who knew how the locking system operated, Brendan Banfield. We saw Christine's phone turned off at 6:46 a.m. and hidden in a drawer in a bar table in the kitchen. This is just not where you keep your phone. This is not where we heard that this woman kept her phone. This is not where a person who's about to engage in potentially risky behavior puts her source of help. A floor away, turned off, in a drawer, off to the side of the kitchen. Just doesn't make sense. We saw Brendan Banfield drive to McDonald's and hang out, waiting for the call from Juliana. We see their call records, 10 and 11, between Juliana, Christine's phone, which is turned off, Brendan, Christine's phone, which is turned off. They're creating a record. It's a plan. It is premeditated. We see this false attempt to check in on Christine so that they can tell the story to the police when they arrive, that they did everything they possibly could. Next, we see the lock at the top of the basement door that Brendan Banfield did not think to engage to protect his daughter. Even under his own version of this event, he agrees he didn't think about it. He left his 4-year-old child in the basement with guns out, stranger in the house, and something happening that caused him to be concerned. We heard the 911 calls. We have a hang up at 7:47 with Joe moaning in the background, and then a 15-minute gap before anyone calls 911 back. 8:02, 15 minutes between when someone in that house thought the police should be there and when they finally asked for help. We saw the body-worn camera and the photos from the scene. Blankets piled near the bodies. Brendan Banfield kneeling on this blue towel. The towel that has very little staining. Completely inconsistent with having been used to stop the flow of blood coming from Christine's neck. We heard that the carpet was soaked through to the subfloor. We saw Brendan Banfield's handcuffs that he didn't use. Magazines full of bullets he didn't shoot, collected from him after the murders. And finally, the blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Bruce that it was Iris Dallygraff's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Dallygraff walked us through so many inconsistencies in this scene, proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence. Slide 15. They have provided no explanation for Christine's blood smeared on the right hand of Joe Ryan, leaving voids between the fingers. They have no explanation for the blood smeared across the top of the right onto the left, leaving that void on Joe Ryan's hand where they had been overlapping. Next. For that matter, you have no explanation from defense for how his hands came to be in that position, neatly folded on his chest, covering the bullet wound that penetrated his spine, immobilizing him. How could that have happened if you are to believe Mr. Banfield? There's been no explanation for the bloody hand-like smears on Joseph Ryan's jeans containing Christine Banfield's DNA. There's been no explanation from defense for how his jeans ended up bunched under his rear. Next slide. There's been nothing to tell us why a mixture of Joseph Ryan and Christine Banfield's blood, a mixture, could possibly have been on the inside of his waistband at the buttonhole, on the button, and on the zipper. Nothing from the defense to explain how Joe Ryan could possibly have manipulated his pants after being shot in the head, given that no other bleeding wounds were present. If his blood is on those pants, on that button, on that zipper, he was bleeding when they were touched. How could he, Joseph Ryan, have been the one to touch his button, his zipper, the waistband of his pants, to pull them down in that fashion? Brendan told you he never touched Joseph Ryan. And yet we have distinctive finger-shaped parallel lines on Joseph Ryan's arm and small circular stains consistent with blood having been dropped from above while Joseph Ryan lay on his back. Next. And then there's the blood on Joe's hip. Blood that traveled onto his body and then ran down to the floor with the assistance of gravity while he lay prone. It couldn't have come from his chest. That wound barely bled. He was laying down when blood was shed. Makes it pretty impossible that he stabbed Christine Banfield. Next. On the other hand, Brendan Banfield has cast off on his jeans. He has blood all over his hands. The blood stains on the backpack don't line up with the position of its contents. The blood on Joe's face is not consistent with his final position. And I'm sorry, I'm back to Joe's hands. This scene was manipulated. And it wasn't by Joe, it wasn't by Christine, and according to him, Juliana didn't do it. You have zero explanation from the defense as to how all of this blood evidence can be as it is. The Commonwealth gave you an explanation. Brendan Banfield and Juliana Perez Magalis colluded to kill Joseph Ryan and Christine Banfield. That makes sense. All of this evidence can leave you with no doubt that Brendan Banfield killed Joseph Ryan and Christine Banfield. That is the first element of the aggravated homicide statute. The hard work is done. Element 2, that the killing was willful, done with a bad purpose, intentional, and deliberate. There can be no question in your minds as to the intentionality of this act, the deliberateness of this act. You must also find that it was premeditated, that at some point before the killing, he decided to kill Christine and Joe. I believe that we've presented you with that evidence as well. For one of the offenses, you find that he killed 2 people within 3 years. As we've identified, same day, definitely within 3 years. For the other offense, you find that it was 2 people killed during the same transaction or occurrence. They were both killed in the room as part of the same plot, by the same person, same transaction or occurrence. The second offense is for the use of a firearm in the commission of the murders. We know from our experts that Joe Ryan died of his multiple gunshot wounds, one of which came from Brendan. If you have any question about whether or not Brendan can be held responsible when Juliana also shot Joseph Ryan, you'll have instruction O, that is concert of action. So I'm going to read to you what it says. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participate in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. Virginia makes it easy. Translate. If you think that Juliana Perez Magalis and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible.
That's why they're going to find him guilty on both.
The last charge is the endangerment to Valerie. So while in his custody, that the defendant willfully or negligently caused or permitted the life of such child to be endangered. He made it out to be Juliana's idea, but he brought Valerie into that home. He left her in the basement, knowing that Joe Ryan was upstairs. He left her in the basement while he shot and killed Joe Ryan. He left her in the basement while he stabbed his wife. He could have locked the door. He could have done this on a day she wasn't home. He could have made arrangements for someone else to have her overnight. But that didn't work with his plan. So he's guilty of this offense as well. I appreciate, again, all of the attention that you've given. I appreciate, again, all of the hard work you're about to face. Please be thoughtful in your deliberations. But at the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today. Thank you.
Just under 21 minutes.
Cross-examination, I'm sorry, closing arguments?
Sarah, may I bring a bottle of water up in front of you?
You can.
Thank you.
I just need to get the
A quick close.
microphone.
It's on. Yeah, it's something.
Jenna Sands wraps it up, puts a bow on it in under 20 minutes for a 10-day trial. Wow. I don't know if there's a limit, but I don't expect the defense to go over half an hour.
Good morning, ladies and gentlemen. Can you hear me? That's been a little bit of a problem, but I have it right on me at this point. I join in the Commonwealth's thanks for your attention, for the time that you've put into this. I intend to present to you with highlights of many of the things that we went through, but I can assure you I'm not going to be going through the evidence that's already been moved in. And it took a long time, and you were very patient, and everyone was very patient.
I'm sorry.
I still can't hear you, sir. You're going to have to take it out of your pocket, sir, and put it on your lapel.
Just a little further up.
Can everyone hear that?
That's better.
Okay. I'll try to speak a little louder. Ladies and gentlemen, I join in thanking you for your time, for your attention. You could see over the nearly 3 weeks that everybody was attentive, and that's something that is something that's crucial to this process, and so I thank you. When my children were younger, I used to walk out of the house and tell them, I'm going to defend the Constitution. They didn't have any idea what that was, and oftentimes that became, okay, whatever, Dad. I was a prosecutor then. I was a prosecutor in Fairfax County. And what that meant to me was
story time.
You presented a case, no matter who it was, you presented a case where you looked at all possibilities and you looked at all evidence to determine and to make sure that you were pursuing someone that the evidence would support. In this case, this was quite unusual. When we first met for the initial opening, I talked to you about some things that I thought you should look into. I thought that you should have an ear towards what is it that they're going to present as evidence. And even I was surprised that the evidence that ultimately was presented by the Commonwealth was actually from my case. The only people that were called to testify from the Commonwealth's case in chief were for body cam video, police officers, a couple of those, and Detective Terry Leach. And he was the one who identified all of the scene photos. He identified many of the pieces of evidence that were brought in. And he was able to talk a little bit about things such as the blood stains on the gun, the blood stains next to the bed. And what he told you, ladies and gentlemen, and this was the extent of, I think, their testimony in their case, was that there are numerous things within this scene that we can see in pictures, but they were never tested. There are numerous things that became the centerpiece of the fantastic story that the Commonwealth tells, yet they were never tested. For example, if I were to have the opportunity to cross-examine, say, the chief detective of this case, I might ask, why wasn't there fingerprints done, or even DNA, of this gun safe that we hear about? We hear Juliana goes into the back bathroom and talks about getting a gun. It changes a little bit over time, but if someone had said they went to the gun safe, because we're talking about guns, we're talking about shooting, why wouldn't there be some sort of evidence to either corroborate or preclude that possibility? I asked Detective Leach. He says, well, it's really up to the forensic examiners. They make the decision. In looking at the scene, you'll notice in the body cam video that you're going to be reviewing, there's a point when first responders come in and you see Brendan kneeling down next to his wife, rendering aid. He just shot Joe Ryan. He testified yesterday he puts the gun down to his right, which is where his holster is. And he also indicates to you in his testimony yesterday that he moves the knife away from Joe Ryan. The staining on the bed where my client put the gun for the first responders, because whenever there's any sort of a shooting, you have to make sure that you are nowhere near the gun in the event that you're perceived as someone who's hostile. He puts it to the corner of the bed.
In case the police read the scene correctly.
The remain were, did anybody ever test the blood on that gun? And you hear from Detective Leach, you can't do that. It was already test fired, and now would be potential for contaminant. Now, we didn't test the stains down on the floor where the gun was lying in before it went up on the bed. And we didn't test the gun, which appeared to be something that a serologist could just take a swab of. Yet there's some significance placed on the fact that there was a blood stain where the gun was when it had been sitting in a puddle. And so that actually was tested. In terms of the blood stain pattern analysis, which appears to be the Commonwealth's main focus of the case now, there are questions about many of the things that Ms. Sand says were never tested. And so the conclusions that are being reached in terms of Brendan Banfield did this, he did this, he did this, based upon whatever blood analysis, is oftentimes not considering the fact that it was never tested. We don't even know whose blood it was. Those kind of things are important. And so let's go back to defending the Constitution. When you are charged with presenting a case, and I chuckle a little bit when Ms. Sands says, we haven't proved anything, we haven't shown any evidence. All we've done is show evidence. All we've done is try to get the truth out there. My client doesn't have to testify, yet he gets up there and he tells a story. He's a philanderer. We can conclude that. It's horrible. It's a horrible situation to be in. He had affairs. He accepted that.
Poor him.
He told you, ladies and gentlemen, exactly what was going on and exactly how it went. On cross-examination, he admitted to communications that were provided, which were letters between he and Giuliano when she was in jail.
This is not the same as being a philanthropist. That's different.
In the beginning, you heard our duty is about fairness, our duty is about being just, all those sorts of things. Yet you don't put on any of your detectives. She's referring to the expert that they have that I called. I called 3 times. And you saw his demeanor. He was very uncomfortable. Why would he be uncomfortable? Why would he have been uncomfortable talking about his work? And we dug for it, and he ultimately said, the executive summary and the data remain the same. The only thing that changed is Juliana Perez Magalay's statement. Excuse me one second.
Got a dry mouth. Deer Park Water, not a sponsor.
So there, number one, that's the first time that anyone in this case, which was when I called him, conclusively said the entire catfishing theory changed upon her plea deal. So let's talk a little bit about confirmation bias, or I think we referred to it when we were talking in closing, or when I was talking in closing about a rush to judgment. You've heard from detectives from Fairfax County. Detective Smith came up and she told you the catfish theory started within weeks of the event. She says, that's not how we do it. We look to the evidence and we follow the evidence. Seems like a pretty reasonable way to go. And that was something that I asked of pretty much everyone that was in some sort of investigatory capacity. That is the way cases go, is the evidence leads you where you're going to go. But lo and behold, what we find out is that that theory is being peddled by the two people in command staff, actually the three people in command staff that you also heard from.
His boss?
You heard from from Mr. Bruch, formerly Deputy Chief Bruch, that when Brendan Miller presented his findings, well, first of all, he said, I didn't agree with his report. And I said, well, what, if any, analysis of the raw data did you do in order to make that statement, I don't agree with this report? He said, well, it wasn't that. I don't know about the data, though he said he was a computer forensic PhD. He didn't take the time to do that. So I said, okay, well, did you ever have Detective Miller come in and walk you through it? Like, show your work? Well, we talked about it quite often, but did you, in fact, have him go through everything that he did to arrive at his work? No, we didn't do that. He speaks to Lieutenant Giacchio at the time, who appears to have a direct line to him, obviating anybody else within the command staff. And what you'll see, and you'll see it in the evidence, there are emails where soon after Juliana Perez Magalhães changes her story, there are emails to Sergeant Ames. And you remember Sergeant Ames, he came to the stand based upon my subpoena and my calling him. And Sergeant Ames was not comfortable. And you could see any of these police witnesses are just not comfortable coming to the stand on my subpoenas and answering my questions. But he did answer them. And what you saw were emails. Those emails were essentially they were just kind of forwarding it up the chain so that his supervisors knew. And he was very candid about it. I was new. I wasn't sure how to deal with a situation like this. I'd never dealt with a situation like this. But what the situation was Detective Miller's executive summary being sent up the chain to Sergeant Ames, who was in a different division than Lieutenant Giacchio, saying there's different ways, there are three different emails that you'll see. Brendan Miller has got to look over this, and he's got to go line by line and explain how he got it wrong, things such as that. The final one is to Sergeant Ames. I can tell you that every single conclusion in his report was wrong. He's going to have to do something in order to, and it's kind of, essentially, he's going to have to change this report because it needs to conform with the proffer of Juliana Perez Magalhaes. So that's twice now. Two different people that I called to the stand that essentially confirms that everything changes when she comes in and testifies. Let's get back to confirmation bias, rush to judgment. When you have people of, in a supervisory nature, you have a command staff chain of command, and the highest people are pushing you on your work product, that's why you look like the people that are up here testifying, because they're sitting on the fence, they're sitting on a razor, and neither side is good for them. But they came before us
on razors, please.
Testified, and they testified as to the truth. Detective Miller spoke the truth, and you could see it. Detective Miller, his work was concurred by
there might be an objection
Mr. Litsky, who you heard for quite often during this period of time.
You can't say a
and it
witness
was
told the truth.
peer-reviewed, and it was concurred by someone, a third party. You heard Detective Miller say, that's never been done in Fairfax County. You heard him say, I didn't ask for that peer review. He didn't know who asked for that peer review. Why would you want a peer review of something if it wasn't for it to change? So once again, not happy with that, not happy with the work product. There's nothing to indicate in Detective Miller's background anything but stellar expertise. But he wasn't introduced as an expert for the Commonwealth. Now, this is where this whole theory went wrong. They discredited him. They disregarded him. And they didn't listen to him. And that's a problem. That's a problem for their case. Because there are things in digital forensics that had he been involved with the group that was talking to Juliana Perez Magalhaes, he would have been able to guide them in terms of this is where the digital forensics is in conflict with you. And you heard me testify, or I'm sorry, you heard me ask questions of many of these detectives.
You heard me testify, yes,
who might have been involved. Did anybody ever challenge her? Were you present when
little Freudian slip.
She recanted for the first time? Well, we couldn't ask that of anyone because the detectives that were in the room have not been called. The detectives that were in the room, I didn't call. And so we don't know anything, but we heard Detective Miller, and he had viewed it, and he said, when I asked him, were there challenges to what was said? He said, no, it was pretty free-flowing. To me, that tells you that whatever the story you're telling us is great, because we're getting bread and Banfield based upon that. Once again, confirmation bias. The first few weeks after the death of Christine Banfield becomes this theory of catfishing, which is what Juliana Perez Magalhaes provides to this. Now let's talk a little bit about digital forensics. And I'm not going to try to use the computer to show these to you because that was excruciating at times. But I think we've gone through it
PTSD
with significant enough detail that when you go back to look at the exhibits, and I'll tell you which exhibits if you wish to write them down, you're going to be able to see exactly what Mr. Litsky was saying. It's complicated. It's been complicated for me since the beginning, but it's not necessarily an easy grasp. But I would ask that you take the opportunity. You're going to have all this evidence to review this particular area. So some of you may have been asking about January, or may wonder about January 9th. That's a significant date in this investigation, because that's the day when the Gmail account, called the suspect Gmail account, was started. Let's just look at how Juliana Perez Magalhaes managed this. Regarding the Gmail setup on January 9, 2023, Juliana told the Commonwealth that she was at the house with Brendan when she witnessed him create the Gmail account that was used to kick off the entire catfishing scheme. The Commonwealth took her at her word. The police didn't make any effort to corroborate her story. The one detective who stood up and said the evidence contradicted her story was transferred off the case. I think the words were from then Deputy Chief Bruce, "That guy will never work on another digital forensics case in major crimes as long as I'm here." He admitted it. There was no dancing around. He admitted it. So you have something that's in opposition to whatever the theory is that you're trying to peddle, and you're in the command staff, you're high up in the police department, you can just transfer them. And so it was from that point on, Detective Miller was of no benefit to the police, because no one would utilize him once the stamp of disapproval had hit him. He was moved over to child sex. Juliana told the same story to you here in court, and it's a lie. The account wasn't created with Christine's phone. I'm sorry, the account was created with Christine's phone, not her laptop, which was the story that Juliana had told. Juliana wasn't even home. She hadn't witnessed anything. And you saw the presentation, and that would be, the evidence would be Exhibit 297, Exhibit 294, and Exhibit 295. They're all in relation. You'd be looking at the Google records, the T-Mobile records, and the subsequent map of where the location was. You heard from Mr. Litsky that the Gmail account is crucial. They all interact. The Gmail account is necessary to get the messages relating to the FetLife, and then the Telegram was created as part of this, whatever we want to call it at this point. Because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine. So let's look at this. There was a period of time, and you heard evidence of it, Brendan wasn't at home. January 23rd, there was a Gmail login at 11:22. That's Defense Exhibit 245. FetLife was accessed. In the communications, you heard Mr. Litsky opine as an expert that catfishing is not a scheme where one talks about their husband or talks about how's your experience on this site. The catfishing in the truest form of the government's theory is we just want to get someone on the hook, and then person's gonna come, and then we're gonna do what we did in there in the house. It's not consistent with catfishing. And you'll see, based upon the records relating to January 23rd, there was only one adult in the home at that time. And that adult was Christine Banfield.
He's already gone 5 minutes longer than the prosecution, and he's just warming
January
up.
30th, there are 2 Gmail logins. 10:36 and 11:03. Exhibits Brendan Banfield 251 and Brendan Banfield 252. Brendan wasn't home. That can be shown. So there are 2 adults in the house. Christine Banfield and Juliana Perez Magalhaes. Juliana testified to all of you. She doesn't know anything about the Gmail. She doesn't know how to activate it. Well, somebody activated it that day. Somebody logged in twice. And there are 2 adults in the house. Either Juliana's lying again, and she did figure out how to do Gmail, or this was Christine Banfield.
That's actually a good point. He just needs more data to make it sink
Digital
in.
forensics, oftentimes, for people who don't understand it, will say things like, well, isn't it possible this? Well, you see what happens when an investigator is looking into, trying to get attribution. They're looking at all sorts of different data facts in order to make a determination, make an opinion. It's not as easy as saying, well, isn't it possible this? There's more to it. And once again, digital forensics is not being given the strength that it is due. February 7th, 2023, Gmail login at 10:02 p.m. There's only 2 adults in the house. Brendan Banfield can be identified as being out of the house, and one of whom says she never did anything with Gmail. That's BB 257. It's been presented to you. You can recollect what it was that was said, but what we know is that Brendan was out of the house. What we know is that Juliana was there, and we know that Christine was there. February 13th, 2023. There are logins in the morning in the 7 a.m. hour. Well, what we know from digital forensics is that Brendan left at 6:05. And at 6:12, he was at Tyson's Corner, based upon his E-ZPass records. At 6:17, he was already to Alexandria. And soon thereafter, he was in Cheltenham, which is the Federal Law Enforcement Training Center. They call it FLETC. Well, while he's on the road, while he's at the FLETC Training Center doing his training, there are 2 logins. And there are 2 possible adults there. Juliana Perez Magalhaes, who has said she doesn't know how to do that, and Christine Banfield. 2:17, You'll see Gmail logins at 11:19, 11:23, Exhibit 262, 263. Same thing. 2 possible adults. Brendan Banfield was out of the house. One said she never did anything with Gmail. A fact that I think is very important in the discovery that was provided both to Juliana Perez Magalhaes as well as my client in preparation for her trial. FetLife was in the discovery, but Gmail was never in focus. Never in focus. So her testimony, there's a comfort level with FetLife because she saw it in discovery. She didn't see the Gmail. And isn't that a coincidence that when asked any details, she says, I don't know. When she says, I don't know, for 5 or 6 questions, I hope you recall it, I recall it vividly. She said, if you keep asking these questions, I'm just going to say I don't know. And she continued to do that. Were my questions challenging, like the kind of questions that a detective might do?
No, they were worse.
No. We were just looking for details.
Sorry, I thought it was muted.
We were looking for details because we wanted to try to iron out what are these situations here. She was unwilling. She didn't know, but she knew I was digging for something. But if you look at the way she testified to all of you in direct, she was led to a certain statement or a certain fact, and she stated it. In cross-examination, I asked anything about that. Do you know who was in the house? Do you know where you were? Were you on the phone on WhatsApp with Christine prior to that? Where were you located at the time that this call took place? I don't know. I don't know. If that's what it says, I don't know. You know, there were a series of similar answers. Once again, her role has grown in importance for this case. It's, along with Deputy Chief Bruce and Lieutenant Giacchio, she's pushing it on through her deal. Now, one of the things that I talked to you all about, and one of the lengthy cross-examinations was relating to a group of exhibits which were number 1 through number 69. And you'll see it. It was highlighted. I think you've seen it for a brief period of time, but we were moving along. Look at that. You'll see these are the personal letters that she would write to my client. And those personal letters, I believe, is the closest to the truth that you will have heard from Juliana Perez Magalhaes. She was in a situation which really was affecting her. And it would affect anyone. And she was telling you how she was feeling. She was telling you what she thought. There were things that were relevant to this case. They're trying to make me turn on you. I'm not going to do it. I don't have anything to say. There's nothing that I can do to help them with. And then you'd see letters as the time went on. I don't know if I can live like this anymore. I think it's better for me to end. And then as she gets closer to a preliminary hearing in April of 2024, you start to see real angst and real worry. And they're coming to her and asking her if she'll testify against my client, because that's what they wanted from the beginning. She was a pawn in trying to get to my client. You'll see this timeline in these letters. It goes toward July. July was the date of her first trial. And you'll see, and I'm not suggesting what she's saying about her lawyer is correct, but it was obviously something that was on her mind, and she didn't feel like she had the support. At that point, if you think about it, the only support that she was having was from Brendan. Brendan was not arrested. Brendan was there communicating with her. Brendan's mom was actually supporting her lifestyle in the jail in terms of commissary, things like that, and also supporting her by having paid for a lawyer. Around August, you'll see in these letters, it gets to be real despair. And then you can almost see hope just drop right away from her when she hears that Brendan's arrested. And then she testified. She went into the hospital from October 13th to October 23rd. And as soon as she's released and back to the jail, the deal is done. She's told, if you testify against him, we'll recommend time served disposition. She can go back to Brazil, be with her mom, create her new life. And we know a little bit about the new life that she's planning on creating. And you have it in the documents that are before you. She's been negotiating with people who are connected to Netflix. She's been negotiating with people who are connected to Hulu. She's been talking to every other news media, at first to try to see if they just put $50 into her commissary. But then she realized, hey, there may be something here. She's invented, she's going to try to write letters. She's going to try to write a book. She wants to have a documentary. She wants to have a series. And she's about to sign or about to agree when her lawyer steps in and says, don't sign that. And so around March of 2025, you see negotiations essentially end. The number was in the area of $25,000, and it was going to be sent to her mother in Brazil. It's a lot of money in Brazil. And so, where's the downside for her? Where's the downside for her? I mean, there are plenty of people who would make that decision, given the circumstances, given you're 2 weeks from the trial, when your attorney asks for a continuance. And oddly enough, he was asking to find a digital forensic examiner. If they'd done that, maybe that wouldn't have happened. Maybe they would have realized how strong the digital forensics examinations are. Her entire story has been bought and paid for. First, with her freedom, and then now a little bit on the back end.
That's a good line. You should have opened with that.
There's a jury instruction here that says something about corroborated, uncorroborated testimony, and you should be careful of it. Now, how did they try to corroborate her? So isn't this funny? They're trying to bolster the witness who's the centerpiece of their entire case. Well, They found something when my client was arrested on his laptop that said they'd just gotten vinyl light windows in December. So, sitting in the meeting with whomever, they say, can you tell us anything about these vinyl light windows? They're triple paned, probably really good. I wasn't there, I don't know. But the story she gave was that, fantastic. We got the triple pane windows because Brendan wanted to make sure you couldn't hear a gunshot in the bedroom. And and she says, he asked me to go outside and scream to see if the windows, and she says, I'm not going to do that. So she ended up staying inside and saying Brendan went out and screamed. Well, you heard the test. This gentleman from Vinyl Light Windows came in. They trotted him up there, and he said, "Yeah, we met in January. That was when we first talked about this, and it wasn't just the windows for the bedroom, which is what Juliana said. It was the full windows, and then you saw an artifact on Facebook that is Christine Banfield actually talking to her neighbors about the numerous vendors that they had been working with to try to get a quote from December 2021. So this is well before Juliana came on the scene, but it's an opportunity to try to make her appear in the know, to corroborate her. Well, that was a disaster, and that didn't work. And you heard the gentleman, what the life cycle of order to quotes to all those things, they were all done well before any sort of relationship started with Brendan. Confirmation bias. Rush to judgment. It continues on. Detective Leah Smith tells us the catfish theory was told to them within 2 weeks. She goes on to talk about the theory and investigation and the direction it was going in. During a period of time soon thereafter, Detective Miller tells of his transfer against his will because he was advised he'd never work on major crimes cases again. Sergeant Ames, after receiving communications from Lieutenant Giacchio, immediately sends it up the chain. Could be just the way he does things, or it could be read those emails. Hey, I'm being asked to do this. I need some support here. When you have a theory that gets pushed from non-investigative command staff, and you have a theory that the investigators look at, then you create something called tunnel vision. And that tunnel vision, if you're following what essentially are orders, is to the exclusion of any other evidence. 44 minutes right now. Any other theory, such as
who's dying in there?
Maybe this is a rekindling of previous fantasies, and the guy who brought the knife to the house is the stabber.
Walk me through that
again. You can see how that theory is going to be pushed aside. And you can see how that's not very noteworthy for purposes of media or other attention.
Or for investigation, because it
once again
completely
rush to judgment.
Doesn't make sense.
Catfishing. If you're catfishing, meaning you're trying to get the one guy, Joe Ryan, to come to the house so that you can do this gruesome act. Why are you saying anything about, I can't have marks on my face or my body? If you're catfishing, why would that matter? It doesn't make sense. It's inconsistent. However, if you're interested in dabbling in this lifestyle or getting back into it, however you want to say, then that makes perfect sense. There's 9 different conversations on FetLife with different people. And you have all of the FetLife communications. And you can see, why would you have discussions where you're bringing things like no marks, anything like that? All you need is one if you're going to carry out what the government's theory is. Why would you give anyone details about your work or your home or your husband if you were catfishing? I mean, if it's truly catfishing, you're looking for the biggest pile of people that might be considered. If you're telling someone that you have a husband and you want them to come over to the house, why would anybody come? You're losing the potential people that you might want to have there who are violent or, love to do all the things that Juliana has said. Why would you do that if you're catfishing? It doesn't make sense. On February 13th, 2023, why would there be generic research on secure apps for communications? In fact, why was there even a need to transition to Telegram? Because if you're on FetLife, it's clear there are FetLife communications. And so in the world of catfishing, if you think about it, you want to do as few things that can get you caught. So what was the leap to Telegram? It doesn't make any sense. In fact, this whole theory doesn't make any sense. And the only way the government can make any sense of it is if Juliana Perez Magalhaes adopts their story once again. As late as February 19th, which would be 5 days before Christine Banfield's death. Under the government's theory, there were dates that were being explored with 5 different FetLife users. Why? If Joe's already coming, why? It doesn't make sense. It doesn't make sense. Juliana Perez Magalhaes is doing what probably anyone would do who's from another country, who comes here for an adventure, which is what au pair exchange is. It's essentially a cultural exchange. And the idea is you get to live in the country and you get to live like people in the United States. And then you go back at the end of your time.
Not quite a foreign exchange student.
She knew at the point
a little more to it
when she was hospitalized to the point of sickness as a result of what was going on in her life that she had to do something. And the Commonwealth and the police broke her. She turned down a misdemeanor, according to her, in January, on January 1st, and you'll see it in the communications. She turned down a misdemeanor, and all she had to do was testify against Brendan. In July, you hear her recounting her meeting with her lawyer, where her lawyer floats the idea, well, what about a manslaughter, time served, and you don't have to testify against Brendan. She agreed to that. That was never what they were talking about. That was never what they wanted to do. You heard from Sergeant Matt Nilsson, who briefly came in, and he was one of the homicide people during the time of the killing of Christine Banfield. He's since rotated out to another division. But he came in and he said the whole goal of arresting Juliana was to flip her against Brendan. Once again, further corroboration. We knew it, we saw it from her letters, and now you have someone who was involved saying, yeah, that was what we wanted to do. That's why we did it. They broke her. In talking about the blood work and the blood testimony, it was suggested by the Commonwealth that we hadn't proven anything. The Commonwealth had not shown anything. Well, I beg to differ. You heard from Leanne Singley. Leanne Singley is an expert. She's an expert with tremendous credentials, and she's an expert in truth in terms of what she's allowed to say, what she can say, what she can't say. And she speaks to you in the language of blood-stain pattern analysis.
Like to be certified.
She's not talking about possibilities. She's talking about facts. She's a scientist. Her counterpart from the Commonwealth was willing to entertain any possibilities. In fact, questioning of her was, well, isn't it possible this? Isn't it possible this? Isn't it possible this? And oftentimes you would hear her respond, well, that wouldn't be something that I would have expected to see, which is a very interesting statement if you think about it. What is it that she's expecting to see? Which makes you wonder, who's telling her what she should be seeing? And does it fit the narrative? So let's go to Leanne Singley. She tells you of the account of the events. Ryan stabbed Christine in the neck. Brendan shot Ryan in self-defense. Brendan rendering aid to Christine. Ryan moved toward Brendan and grabbed Brendan's arm. You see that in the videos. And Juliana shot Ryan to end the threat. What Leanne Singley tells you is all of the blood evidence supports this. Ryan brought the knife. That'll be Commonwealth's Exhibit 10. The knife has blood on it with Christine's DNA on the blade and Ryan's DNA on the handle. Ryan has Christine's blood on his hand as well as a puncture wound, which the medical examiner says is consistent with the knife. And if you look at the knife, it's described in the certificates of analysis as testing underneath the handle by the edge of the blade. And if you look at the marks on Joseph Ryan's hand, the medical examiner states that these wounds are consistent with that knife. Which reminds me, the medical examiner also said that Joe Ryan was capable of movement. And you can recall your own notes on that. That was very clear, which is in absolute conflict with Ms. Groff and is in absolute conflict with the Commonwealth's theory. She further goes on to say, Ryan has Christine's, the blood on his hand shows his hand was closed when the blood was deposited. That's that closed fingers we were talking about. That's what the Commonwealth was talking about in terms of having nothing going in between the fingers. That's holding a knife. That's how that happens, because you're holding it very rigid in order to do that. The bloody handprint on Ryan's thigh is consistent with him touching his own leg with his bloody hands. That's Ms. Groff. The stains on Brendan's jeans and shirt are what you would expect he would get while giving aid to Christine. And we see it. We see it on the body-worn camera. We see it on the still shots.
Who's the guy in the
He's
green
leaning down.
Patagonia
He's
jacket?
down there on his knees.
With varying degrees of success. Where was the towel?
Testimony
It was
by
just bare hands on
Ms.
his neck.
Groff and the ME indicated that Ryan could move after the gunshot. And what's most important is that there's a DNA mixture of Christine and Ryan on the arm of the jacket where Brendan said he was grabbed. 3 times. 3 times when he was being told by the first responders, go into the bathroom. He said, they're asking, is he okay? He hit me on the right side under the shoulder blade by the arm. He said that. Then in the ambulance, you'll hear that. He says, when they're asking, are you okay? Are you okay? I don't think I'm injured, but he did hit me on the backside of my jacket. In the ambulance, they grabbed the jacket. And then when he was in the hospital, the doctor asks, and he says, he hit me on the back, but I'm not injured.
Was there blood on the jacket? You've been stabbing
critical
Christine.
part of that is that the DNA mixture of Christine's blood and Joe Ryan's blood on the jacket was, if you were listening to my client yesterday, he tells you that that was Joe Ryan after he shot him. That mixture of blood with Christine and Joe Ryan himself had to be after Joe Ryan had stabbed Christine in the neck. And that's the way her blood would get on him in order to be able to get the back of my client's jacket. That's what Ms. Singley says. And that's why the Commonwealth is so intent on saying this had to have been on the floor, this had to have been on the bed. But there's no evidence to support that. There's a story to support it, but there's no evidence to support that. The
Meg,
evidence
thank you so much.
in terms of what happened in that room, and the crucial evidence is spot A on the back of the jacket, and you have it in evidence, and you also have it under Commonwealth's Exhibit 160, 161, and 167. Poor officer, I'm sorry, the young man who was 1 year on, I forget his name now, he was brought up to introduce his video and then was asked, well, why'd you let him wash his hands? And you can see my client, for a period of probably 40 minutes, is literally walking around, you know, in a trance from what he was just involved with. And he was walking around with blood. He went into the bathroom and did it right there after being removed from rendering aid. Brennan's DNA does not show up anywhere on Joe Ryan, which is consistent with what he told you, which is that he never touched Joe Ryan. There's no indication that there was any sort of movement, and frankly, what's the possibility, I guess I'll use the same word, that a 185-pound man would have been moved if he was otherwise dead? It's not an easy task. And Brendan Banfield's an athletic guy, but I don't think he's up to moving 200 pounds in that sort of way. So that's an absolute red herring in this.
Mr. Carroll, do you have quite a bit more? I just
passed an hour.
Probably about another half hour.
Yes, let's go ahead and take our morning recess for 15 minutes. Please do not discuss the case at this time and do not do any outside research.
Judge invokes the mercy rule. Says you've been speaking for over an hour. And this has not been the sort of TED Talk that you can't wait to play again.
Just come back at 11:55. All right, 11:55. All right.
Thank you.
All rise.
Interesting. Screaming goat, a little bit. I'll give him a couple things. There are a couple points that he brought out that are good. And that's anytime he can show that Juliana lied. That helps the defense. The whole, she told you that she never knew the Gmail login. She never had that. She didn't know how to do the Gmail login. But then she also told you that all the FetLife communications were either her or Brendan. But there are Gmail logins intermixed with FetLife logins and access on the computer that happened when Juliana and Christine were home, but Brendan was not. That would indicate that Juliana may be lying about her level of involvement. Or, as the defense would like you to believe, that Christine was involved in the FetLife login, which I find very, very incredible. Should have been a time limit. The judge, a lot of judges do limit the closings. This one's turning into a filibuster a little bit. Where we've already talked about the defense's case, where he's now going into the prosecution's case. I don't know why you would want to remind the jury of the prosecutor's evidence right before deliberations. I think they've got enough on their mind already about that. But another half hour or so to go. Most people have their Gmail password already memorized in their own computer, but she testified she didn't know how to get into it. So. She has immunity. Super T, yes, she does. She has done her part. As a matter of fact, regardless of the outcome of this trial, Juliana has completed her portion of her agreement, which has provided all the evidence that she said she would in testimony, and been cooperative and answered all the questions that the state presented to her during her time on the stand as a witness. For that, she is going to, even though she's pled guilty, she has not yet been sentenced. She's going to have her sentence most likely, I say most likely because the judge still does have the authority to veto that, most likely chopped down to the prosecution asking for time served as the maximum penalty, which basically means, hey, she's done enough time in jail, she's paid her price, just let her go, and then she would be deported back to Brazil, and where she would just, upon arrival, would, try to set up her life however she wants. Now, how she's planning to do that is with book deals and movie deals and things like that. So there could be a significant amount of income, especially, the exchange rate and everything in Brazil, how far that money goes. It could be quite a bit of money for her down there, and she just gets to move on. Chris Wallace says, with my short attention span, RA has won me over for 31 months. Chris Wallace, thank you very much. Oh, gee. Ryan Hollyhall's going live here in a couple hours. I know, and he's talking about my neck of the woods. And Max Velocity is talking about my neck of the woods, and well, I really don't have room to complain. The last storm missed us. I mean, we got like nothing, just a little bit of ice on the trees, and it melted. Never even got on the roads. Does the state still get to have another go? Does the state still get to have another go? Yes, they get 2, just like you get 2 questions per super chat. Just kidding, Lacey. I don't know why it typed it twice. Sometimes it does that. We do expect that the state should have, basically their rebuttal moment, and then it'll be done. I don't think it's going to be 10 minutes. I think it's going to be quick. There's only a couple states where they don't do a rebuttal on closings. We just actually had a trial there. Where I don't remember what state it was in. Glad it's not in my neck of the woods. I don't know what we're going to do with 12 to 15 inches of snow if we get on the high end of what they're predicting for here in eastern North Carolina. I can tell you what I won't be doing, and that's metal detecting. Metal detecting and deep snow, it doesn't go well together. I probably also won't be going outside. If you see Reed Timmer run, if he comes here, yeah, it's too late. It's too late. Let's see. Go live in snow. I might do that. We might live stream the snow. I would have to most likely. If it's not blowing wind really hard, if it's not blowing like terribly hard, I might take my camera, my pan-tilt zoom camera, set it up on the front porch, and just live stream the snow, and any cars running around. Might be able to put do you think I can mount a camera on a telephone pole without getting in trouble? Not like way up tall, but like down low. Oh, that's not my property. I probably can't. We might show the snow. We may be working tomorrow. Here's what I know: if we had any plans tomorrow to go somewhere as a family, they've pretty much been canceled by the weather. So the odds of me working tomorrow are really high. We do have some catch up to do on the Canero trial, as we're going to be going to that after this verdict. So we'll probably be working tomorrow. That's like 3 weekends in a row. Let's see. There are lots of live streams of snow on YouTube. I live next to Lake Erie, so I can look out the window. Maybe if I get really creative. No, I won't do that. I was going to say I could put up a pan-tilt zoom camera that you guys could control through chat messages, through commands, but that I just thought that all the way through to its natural conclusion, decided that's not good. I should probably think before I speak. Let's see. As far as the case goes here, the jury's about to deliberate. I think if the guy in green we keep seeing in the audience in the gallery is any indicator, everyone's ready to be done, right? They're wiping sleep from their eyes. They're struggling to stay awake. They're like, is it still going on? They're ready to be done. Even the judge is like, look, we need a break. We can't just keep going like this. It's got to be done. But at this pace, we will be deliberating basically right after lunch. Send them to lunch and deliberate. He's not done. He's gone 1 hour, 2 minutes, and 8 seconds by my clock, and he says he has half hour left. He's already covered all the evidence that he brought in defense. Now he's talking about things the state has. But his best stuff was that one-liner about Juliana, that her story has been bought and paid for multiple times. He should have opened. That was an opener. Why would you bury the lead like that? Okay, because honestly, just like we heard it opened from the defense, the only thing they need to attack is Juliana. There are big holes in this case without her testimony, and if the jury will discredit her testimony, I don't think they could come to a conclusion of guilt at the level these things have been charged without it. So if they can discredit her and prove that she is lying, then mission accomplished. Why would he not open with that? I think she is lying. I think the only thing that there are parts of Brendan's testimony and Juliana's testimony I believe is true, and and one of those is that that Joe did hit him on the back. I think that happened. I think it happened after Christine was at least stabbed at least once in the neck. That explains the blood from Joe and Christine. After Joe was shot at least once, that means he was shot in the head but not killed, and he was able to move. And it would also explain why there's that second bullet. I think, as I think Legally Blonde suggested yesterday, that Joe was trying to stop what was going on to Christine. Why else would he attack the guy that just shot him? He knows the guy has a gun. He knows the guy has a knife because it's the knife he brought. Why else would Joe attack that guy? And I also think that Joe did ask if he could leave. This wasn't what he signed up for. I think he did ask. I think that part was truthful when Brendan said that at one point Joe asked if he could go instead of be killed and left at the crime scene. Anyway, let's see. Which makes it so much worse. For those that are asking, yes, I did winterize the pipes in our Airbnb just in time because the renter just showed up. And so we're good there. So no broken pipes. Why has no one mentioned any motive whatsoever for Joe to kill Christine? Bartholomew, you basically, you have to leave that as a big question mark to accept Brendan's story. You have to leave why Joe would do this is just like, that's for someone else to decide. Don't even think about that, because all Joe's actions look like it was a hookup, right? It was a kinky hookup is what Joe was signed up for. And he thought it was all above board, drove his personal Jeep right up there, parks in the driveway, texting back and forth, doesn't hide anything. And then decides, oh, now I'm going to commit a murder. Okay, people that commit murders like to get away with it, and they like to hide evidence that would catch them. I just don't see that happening, especially if no stabs had occurred when Brendan entered the room. That he went from, hey, this went from something kinky to, oh, wow, I thought it was going to be the two of us. Now I'm going to kill you. Well, the husband is there with a gun drawn on me. What? It just does not. It just does not stand. It doesn't pass the smell test. Atticus PMA on the jury, 2 months. Am I pink yet? Not quite, Atticus, not quite. But thank you so much for your support. Appreciate it. Let's see. Also, we have Hippie Mimi, member for 3 months. Love this channel. Hippie, thank you very much. Appreciate it. Poor Joe, he's been lost in all this. I've never seen a pic of him. Unfortunately, the pictures the jury has of him are mostly crime scene photos. But let's see. If this were retroactive, I'd be pink. That makes you an OG. They've shown one photo of Joe to us. Brendan has absolutely no reason to lie. As any narcissist, he's faultless. And I'm surprised he didn't wear his cape to court today. The guy's father of the year and husband of the year. I mean, who else wins both awards? Joe was definitely lost in this. Not just lost, but Joe was blamed as the victim. Or as the victim, he's blamed for everything that happened. And Christine, as a victim, is blamed for everything that happened. Literally, the two people who lost everything in this are being held up as the people who were the problem. Coincidence? I think not. It doesn't stand to reason. It doesn't pass the smell test. Princess Sugarplum, thanks for the super chat. Thank you for all you do for this channel and podcast. Thank you. The podcast took a hiatus yesterday because Weather Watch was under the weather. So we'll return next week with more. I think next week we are testing that product. We're going to be taste testing a product that probably none of you have ever had, and probably neither of us will ever have again. So you don't want to miss that one. Love this channel. Thank you, Ari Mods, for the chat and for the best place to watch true crime. Thank you, Jess. 24 months. You just hit the 2-year mark. Congratulations on the pink courthouse. It looks great. Brendan's defense is just pitiful. Thomas Jules, I've struggled with the style of the defense attorney, the way he paces his questions, the way he words his questions, the way, especially when he has a bunch of evidence to get in, and he runs into a roadblock using the method he thought he would get each one of these items in, how he still does the same thing over and over with each item of evidence and then runs into the same roadblock. I mean, they say that the definition of stupidity is doing the same thing over and over and expecting different results. We get that from him on evidence. We had 2 painstaking days of that with his expert. It's almost like he had this plan and he's sticking to it no matter what. And he can't be fazed. I guess that's a good thing for an attorney, to be able to stay just level-headed and focused. But he won't adjust when his course of action is not producing the results he desires, even when presented with another course of action that would. So that part's a little bit difficult to sit through. That, and I get PTSD anytime people have electronics issues, and he has a lot of them. All right. I think verdict will be Monday, says Yogi. Laura Fry says, all right, don't forget to mention the like button. I like the like button. Of all the buttons on the YouTube page, the like button is my favorite. It too can be your favorite. Please indicate by pressing it one time. How about that, Laura Fry? How did I do? I say verdict today, says Lobo. Jury is tired of being tortured. The jury, this is ahead of schedule, right? The jury was told basically by early next week they'd be done, if I remember correctly. And so, it's a plus. Maybe the jury is saying, hey, we had planned on a little more time. Let's take our time doing this. I don't think a lot of them are like, it's a big whodunit, right? We're trying to figure out what happened, who did what or who shot who. I think the state and the judge's instructions were clear enough that no one on the jury is going to say Brendan is not guilty of Joe's death, which would make him not guilty of the aggravated murder, which has to be 2 deaths. I just don't think to get to that point, the jury member would have to think that it was that Joe's shot, which he admitted he fired at the guy's head, right, and hit him in the head, that shot was not fatal and would not have killed him. And then B, that there was no plan between Juliana and Brendan to kill Joe. Both those things would have to be true, and also they have to believe that Juliana's bullet was the only fatal bullet that shot and killed Joe. That's what they have to get to find a not guilty of aggravated murder for Joe. I guess the other way they could get there is find that Brendan did not kill Christine, because aggravated murder needs to show that he killed both of them. But I think it's going to be a conviction personally. Red Pan says, "Oh my goodness, I just got the preview of Bree's emoji cap.
Okay.
You're in for a treat." Okay, we're back. We're
ready for the jury.
You will bring the jury. If you've never been here for one of Bree's recaps, sorry, Bree will recap the entire trial using emojis only, and it's amazing. It's amazing. There is a juror that needs to go at 4:30 today. No recaps. I'm sorry. Those are different. Okay, 1 hour and 2 minutes, 8 seconds into defense's closing. We'll start that timer as soon as Mr. Carroll starts talking again to get the total time. For comparison, the state so far, on the first of 2 attempts to speak to the jury, has used 21 minutes. I don't think they're going to try to take equal time. I think the state's reading the jury a little bit better. All right, Judge, take it away.
Thank you. All right, Mr. Carroll, you can continue. Thank you.
Thank you, Your Honor. Ladies and gentlemen, we left off in the discussion of the blood stain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of blood stain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that. And it didn't pan out. And
Those
you'll
true
see
crimes,
the
thank you
report.
so much.
Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb, that was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that. She was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or it sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing blood stains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm, you don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor. One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. I called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhães are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity.
I don't think he can tell you which witnesses are telling the truth. This is the jury's prerogative.
The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right sleeve, mix of Ryan and Christine. Brendan indicates that Ryan grabbed his arm on Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans, the small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him when you look at that video, and he's sitting there, and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And This is Defense Exhibit 156.
So that's Juliana lying.
Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based upon this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Inova PICU, and right above a message from Nicole at Inova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing and consistent with someone pursuing a fantasy.
There's catfishing, Josh.
February 23rd.
Love you, man.
We saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, you know, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this.
Well, Brenda went to the bathroom for 7, so yes.
The Commonwealth.
Thanks, Josh.
The Commonwealth's, I guess,
appreciate it,
concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise, and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed the searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie, and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging, social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th.
Did he say finally?
Juliana was not awake and not out of bed based on her devices at the time she claimed to be watching Brendan Manfield sending messages in the kitchen. You heard Mr. Litsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. you'll see Juliana Perez Magalhaes' first steps at 626. Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent, in conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354,
I don't want to see any
355,
exhibit from when he was there.
356. Those are timestamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41. Exhibit 361, Juliana's watch resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom.
That wasn't the plan.
Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying police. That officer was standing in the only way to get out of that room, other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he was going to be arrested. He had marijuana in his system, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and there would be questions that you would want to know. Because you have a decision before you, and that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this, yet the story continues. This isn't how justice works, and you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case.
It's coming close on an hour and a half here.
And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit. And it's not on you. I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And might leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. Switch over the mic again, Mr.
Carroll, yes. All right, so he actually went under the half hour extra. We only went 126, so another 18 minutes or so. Oh, that's bad. You got to fix that. Okay, thank you. Hour and 26 minutes, 32 seconds roughly for him. So now adding to the 21 minutes that the state has already used. If they wanted to, they could go an hour and 5 minutes to equal what the defense used. I don't think they will.
All right, just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Frisler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, what, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's gonna give up that shot for 10 grand? I just don't buy it. Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support?
Members of the jury, this is an important case to both the Commonwealth and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, the verdict must be unanimous. The first thing you should do when you get back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict. To do so before all jurors have had an opportunity to consult with one another and exchange views and opinions might allow your sense of pride to prevent you from retreating from an announced position, even when shown that such position is unsound. You have a duty to consult with one another and to deliberate with the objective of reaching an agreement, if it can be done without offending your individual judgment. Each of you must decide this case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is an error. However, none of you should surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In the jury room, you will have the exhibits that were entered into evidence, you will have the instructions of law that I just read to you, and you will have the verdict forms. Much of the evidence in this case was in electronic files, so you're going to have a clean laptop that's going to have those files on there for you, and that you will be able to access, and you also have the big TV in the jury room that you can plug in the laptop to that so everybody can view the evidence at the same time.
The poll is up right now.
As far as the firearms and knife, the Sheriff's Department has control of those items. If and when you want to see those items, you just have to let the deputy know, and those items will be brought to you. Only the deputy will handle them, but you can ask her to manipulate them however you wish to have them manipulated. But please do not
Aside from
have
demonstrating the
any
knife.
deliberations while the deputy is in the room with you, okay? Wait till the deputy leaves before you do that, okay? All right, so during your deliberations, until you are discharged from jury service, you must not communicate with or provide any information to anyone who is not a member of this jury by any means about this case. You may not use any electronic device or media to conduct any independent research about this case, the legal or factual issues in the case, or the individuals or attorneys involved in the case. You are not permitted to consult dictionaries or reference materials, search the internet, visit websites or blogs, or use any other tool to obtain information about this case to help you decide the case. Do not try to find out information from any source outside the testimony and the exhibits received as evidence during the trial. You will have, again, you also have with you the verdict forms. There's 4 charges in front of you, okay? So you're going to have 4 separate verdict forms, all right? Once you have decided, have made a decision, each of the verdict forms should have the foreperson signature at the appropriate place. There's places for guilty and not guilty for each count that you've heard, 2 aggravated murder counts, 1 firearm count, and 1 child endangerment count, okay? So each form is separately. So each form, upon the finishing of your deliberation, should have the signature of the foreperson just on 1 space on each form, okay? If you sign both places on the form, it gets confused. If we're confused, then that's not the way it works, okay? So just make sure you do that. Okay, now for the last part before you deliberate, the fun part. You remember that in the beginning of this case, I told you we had randomly selected 4 people to be alternates, okay? We still have 4 alternates. Thank you all for your service and being so professional, and even during the snowstorm, making it here on time, and we do appreciate that. And let me just say before I release the alternates that I know that this trial has been a huge sacrifice for you all and have taken you away from your lives for 3 weeks now. I know I speak for all of us associated with this case that I want to thank you for your service in this matter. I know it is hard to have come this far and then not get a chance to deliberate, but that does not lessen the respect and admiration that we have for you. As an alternate, you will not deliberate, but you will still be under the order of the court, okay? And so you cannot do any outside research at this time in the case, or you can't talk to anybody about this case at this time because you're still under oath as a juror. That is because if something happens to a juror during deliberations, I will call you back to service and deliberations would start again as you would be part of the jury as well. So that's why you're still under the order of the court. You are under these restrictions and your oath until a verdict is reached. Once a verdict is reached, we will reach out to you and contact you and let you know this has occurred, and then you are free from all your obligations, okay? So again, thank you for your service. At this time, I'll call the alternate jurors, and if you could go with the deputy, we have to collect your items, and we'll get you on your way,
Get
okay?
your dozen eggs
so the
out of
alternate jurors
the
I
jury
have
room.
are number 26, number 24, and number 38.
The audio
So if
guy
you could
was
follow
quick on
Deputy
that,
Johnson out
worried
at
she
this
was going to give
time.
names. So she read
26, 17, 24, and 38.
26, 17, 24, and 38. Okay.
1, 2, 3, 4.
One more person needs to stand up. Who forgot their number?
Okay. So ladies and gentlemen, these are the 12 jurors that are going to be deliberating in this case, okay? You can take as long as you need to deliberate, and at this point, you can take breaks whenever you wish to, and you can let the court know. If you're still deliberating next week, you can let the court know if you want to come in at 9, you can come in at 9, or if you want to come in at 10, that's fine. When you're
11.
done for the evening, I know there's one juror that has to be done by 4:30 today, so make sure we respect that timing for that juror. But you can take breaks whenever you wish. You can take your lunch breaks, and you can make them an hour, you can make them a half hour, you can do what you like. It's just important that you do not deliberate at any time unless all jurors are in that jury room at the same time, okay? So during breaks, we don't deliberate, okay? We make sure we take care of that. All right. Do we have another deputy that can? All right. I can excuse you now to deliberate at this time if I have a deputy.
If we have a deputy.
Judge, while we're waiting on that moment, can we approach on one?
Sure, sure.
Great. We've got a poll up right now that you get to weigh in on how long you think the jury will take to reach a verdict. We have 4 answers. The first 3 would involve a verdict today.
Gentlemen, just one more item before you deliver. If for some reason you have any issues with the laptop, please let the deputy know. And if you're having trouble with any of the exhibits, let us know, because we can print out anything and everything that you need, okay? So if it gets frustrating at any point, just let me know, and I'll make the parties print anything out that you need, okay? All right, thank you. You can now go to delivery.
All right, let's let them head out. We'll start the timer.
Is the laptop ready?
The laptop's ready. And shut the door. There we go.
If you want to review the verdict forms before they go back as well. The laptop is coming from IT, so if you want to wait for that too for me, so just so you can make sure the laptop is clean and everything, all your exhibits are on there, and then that will go back to the jurors, okay? All right, we'll be in recess then.
Thank you. All rise.
All right, we are now in a waiting period where we just hold tight. Let me get the timer on the screen for you. We're going to talk a little bit. We are going to take a lunch, then we'll come back in the verdict watch. Might do a little court hopping with the little timer going in the bottom while we just, sit and twiddle our fingers while the jury does all the heavy lifting, as they've been quite attentive, according to our court watcher, Rob from Law and Lumber, who was there in court and did get a chance to take a look at the jurors and what they were like. He says there were a lot of them were taking notes. They were quite interested in what was going on. And a good spread of individuals represented there. Give me a second. I'm still trying to stall and talk at the same time I'm building the view here. Let's see. Box source 3 is going to be 8. There we go. Oh, 4 is going to be 8. How about that? 3 is going to be black. 3 is going to be off. Hold, please. There we go. And box 2 is going to be camera 3. Come on. Almost ready. It's a lot of work to get the timer on the screen, but we'll get there. All right, we're almost there. You have the top of the timer. All right, verdict watch has begun. The painful closing was mostly on account of the defense being an old windbag. I hate to use that term, but just using 1,000 words when 100 would suffice, and there was a little bit of disorganization. I'll give him a pass on that. But mostly it was just the amount of time that he took to get to where we needed to be that I had a problem with. All right, box 2. Let me see if I can show you. Actually, show you the timer. That would be great, right? Oh, and it's tiny. Let's make it big. And chop it down. Cut the top down and cut the left down and get rid of all the millionths of a seconds that you guys are not a big fan of. Let's move it over just a tiny bit. There we go. All right, there's our verdict timer. Who needs a professional? You got me. All right, I fixed Anna. I just had to move it in the right place. If you'd only limit it to 1,000 words, I wish. All right, making me feel good about having skipped the defense's closing. I think what he should have hit harder is possibly stick closer to his open. Focus on Juliana. That is a vulnerability point. Okay, first of all, don't just focus on her, but go over that instruction which the judge read at 120 miles an hour that said, be careful when convicting someone solely on the evidence of a co-conspirator. If that's all you have, there's a warning right there in the instructions. Highlight that for the jury and say there's nothing else that tells you what happened right here. That should have been the go-to. Open with Juliana's testimony was bought and paid for over and over. That was your open. That was the grab your attention. That's the focus on the, hey, you can't trust everything you heard here. Now, personally, I did. I trusted Juliana a lot more than I trusted Brendan when they got up and talked. But from a defense perspective, that's the angle you want to start at. That's where you want to hit and leave the personal attacks out. I'm saying this for both sides. Both sides. The fact that this got personal between the two of you, and you're like, hey, this guy, so what are they even thinking? Did they even listen to the evidence? That doesn't fit. That doesn't belong here. I don't think that was appropriate there. Both for Jenna Sands and for Mr. Carroll. They both sort of, and Jenna, a chat pointed this out, pointing out that he had messed up his numbers once again after you both messed up your numbers throughout the trial. Not a good look. Not a good look there. So that was a little he said, she said case. Pros won, hands down. He flubbed up on the stand. He did. Oh my goodness. That's what the state should have focused on a little bit more. They already said he got up on the stand and he lied. It's like he could not even look his boss in the eye the whole time the boss was on the stand. He found something really interesting to write about. And normally he's doing this. He's looking, he's talking, he's looking at the jury. The boss is on the stand. It's heads down. Bam. Nothing. He could not look at him. And I'm sure the jury caught that, though. Has Brendan been out on bail since his arrest? No. No single tears from loving husband. We saw during testimony at one point of Brendan with a handkerchief, and I should have pulled this for you. And he initially, on the initial glance, appeared to be crying. Only on rewatch, when I went back and watched it myself, did I notice that it was more wiping the brow. That he was crying from like the forehead and like the cheek up. His head was down and he's wiping up here in the top of his eyes. And gravity doesn't work that way. He was doing a lot of wiping and waving the white handkerchief, so to speak, to get people's attention. But the tears part wasn't working. It just wasn't there. So that part didn't sell to me either. All right. Anything else we need an explanation on? I think the law is very clear what they're doing here. The wording of the two murder charges. One of them is a charge that you can be found guilty of killing two people. That's aggravated murder, and that has one sentence. But the state really wanted to have two murder verdicts, right? So each person is represented and found guilty. That's important for the family. Imagine if they went to trial and there was, we're charging you with murder once, right? One, you committed murder and they're found guilty, and what the family's like, is that justice for me or for them? Which family gets the closure here? How is that allocated and assigned? They wanted those two charges. It was a little bit of a mix-up this morning. They fixed it. So there are two charges there, and I think they're going to convict on both. What's the max for aggravated murder? In Virginia, life without parole. Did he ever say who his meeting was actually with after his boss busted him? I don't think he said the name of his boss in his testimony, and he did not get up on the stand again and testify after that, but his boss basically said, everybody it could have been wasn't there. It would have been me. I was out of town. It was only me because I was in charge because that boss was out of town, and their two bosses were also out of town. So it's like you don't have a big meeting about a promotion, go to work in jeans and a T-shirt, and expect to do a big presentation, career-changing presentation. I'm going to be made to, senior special agent, something. I forget what it was. I didn't buy that. He didn't have any other managers to meet with. His testimony was so odd to me. The way he spoke, very broken up, pauses like he was trying to get his words right. I think he messed up his words sometimes. The wording where he said there was no plan at that point is a qualifier. There was no plan at that point. Sir, did you plan to kill your wife? When you went there, were you planning to kill your wife? At that point, I was not. That's basically what it comes back as. At that point, I was not. He said, the way you worded the question, I'm going to have to say no because of that time issue. And he said that. He said there was no plan at that point. Why would you qualify a question like, did you plan to murder 2 people that day? Not yet. I hadn't not quite yet. But that was terrible. There was some other stuff as well like that. A lot of the we's. He said we when it should have been I, about unlocking the gates and going in. He said, I'm trying to remember. He used we too often, and then he used me too much. My, when he starts describing, he goes up to the bedroom, and there's my bed. There's my bed, not our bed, not our bed, not our bedroom, my bed, which just seems a little fishy and strange, considering married couples typically share things like that, right? I realize you can have separate finances and separate offices, and that's great, but this was my bed. Where was her bed? Another point, let's see. Trying to think, there was something else that was on the tip of my tongue that I can't remember. Yes. When he said that his wife was still around. When they're talking, I forget what this was the line of question. Might have been relationship issues or, with Juliana. My wife was still around. Like, we hadn't got rid of her yet. Just terrible phraseology for someone who's on trial for murder to say on the stand. Lots of distancing language. Remember, they fell in love because Christine wasn't around anymore. That's love. Let's see. When he wrote the letter to Juliana in jail, oh my goodness. Yeah, he never actually loved Juliana. It's like, I had some feeling, a level of feelings for her, but I let her know up front that, this is just a side thing because it's convenient. His letter said otherwise. Please come back to me. Please talk to me. I love you. Everything else. Those were in the letters. But 14-page love letter to someone who's just, a side chick. Then the master bedroom together. I mean, the only thing that could have looked worse is dancing on her grave. That is just that's a spit in the face of, that is so bad. All right. His wife and his daughter were separated. Let's see. Anything else? He's such a player. Oh, my goodness. Okay. Now, I probably shouldn't say this, but I will anyway. I'm sorry. But it seemed that after hearing his testimony and how he had, I'm talking about Brendan, when he took the stand and recounted his version of the events, especially the relationship side, whether it was with his wife, with other previous affairs, or Juliana. Bree. Oh my goodness. Bree, you've done it. You've done it. Is it a double? Okay, Bree makes a story in emoji. So hold please. But let me finish my thought here, and we'll try to break down this. We'll break down these emoji stories. He presents himself as being like Fabio, right? Like everyone's falling at his feet. Women love me. What can I do? It's a curse. It's a cross I bear in life. It's all I can do to fight them off, right? And I really expected at the end of of his testimony to, I thought, with that idea, if he has any influence over his lawyer's closing statement, his lawyer's going to close with saying, and by the way, my client is 6'4", has a healthy head of hair and strong, bigger than average size hands. It's just he's trying to build himself up to something that's like the evidence is not there, my fella. It's just not there. Okay, we're not what you see and what we see are different. Bree, let me take a look at this really quickly. Wow. And where did it go? Help! I've got it on screen, but I can't find the other one. Bree, you might need to repost it. Oh, there it is. I got it. Okay. So starting at the beginning, we've got, hey, I'm from Brazil. I'm going to fly to America and be a nanny for a couple with kids. We go to their house and move in and quietly have an affair with, let's see, didn't put a ring on it, I'm guessing. And then, I don't know, went somewhere spent the money on the windows for the house, 3-story house, so it was quiet and no one could hear. They went target practice. They went shooting target practice at the range together. Both of them used the computer and the phone. They play web fish. They play catfishing. They were trying to catch a catfishing. Then here comes Joe, who comes. Oh wait, no. This is Brendan, who leaves, gets in the car, goes to McDonald's, spends 7 minutes on the toilet, and then comes back. There's no phone in the car. Oh, this guy comes with no phone in the car. So this is Joe. So Joe arrives. We've got the McDonald's trip with the 7 minutes on the toilet. Brendan leaves his phones in the car, brings the knife, goes to the house while she is sleeping. Christine doesn't know about it. Or no, the au pair doesn't know about it, and because au pair is the one from the blue shirt, calls Brendan, and Brendan comes to the house to see what's going on, and there he not sure what that is. He listens, hears the lovemaking going on, but then decides that it's not, and goes upstairs with his pew-pew, sees Joe with the knife and his wife. We've got the 911 call, then a hang up, 15 minutes, then another call before medics are sent. The police are looking at the scene and arrive, and they see that's Brendan sits down in the tub, and then we've got the purple bed sheets are photographed. Brendan and the au pair she gets locked up, and then she tells all. She gives the missing puzzle piece, and the judge, the blood world magnet plus meat. I'm not sure this part right here, Bree. I'm struggling on the tail end. How am I doing? Am I remembering the case? That is awesome, Bree. The blood world magnet plus meat chart. Oh, gravity magically pulls blood down. Okay. Bree, that is incredible. A new level of greatness. Thank you, Bree, for summarizing the entire case in emojis, as you have done quite a lot for us recently. We really appreciate that. Let me move this timer so you can see a little bit more. Okay, we are at 18 minutes and 16 seconds. We are going to... I'm getting it slowly. I'm starting to learn emoji speak, Bree. So I'm going to be able to talk to my kids eventually. Let's see. She said to check the burner phone. Let me check really quickly. That's not the burner phone. That's mod chat. There's the burner phone. Oh, wow. Summary. Oh, I had a cheat sheet. You sent me a cheat sheet all along. I nailed it first try. This is perfect. That's amazing. Bree, that's amazing. Thank you very much. I got it without that. I'm pretty impressed. All right, we are going to go to lunch. We are going to we're going to go to lunch. Let me end the poll first of all, because we have a poll running right now about how long the jury will deliberate. Let's close that. Ends the poll. We're also going to unpin the message. Oh no, we're still on Verdict Watch. We'll leave that pinned up. The poll shows that. Question, how long will the jury deliberate? 2 to 4 hours. We have 53%. That would put 53% of us put it later today. Another 28% put it in the next 1 to 2 hours. Only 2% say less than an hour. And 17% of us say it's going to happen over the weekend, which could be a problem because this area, Fairfax County, Virginia, is also included in the area that may get clobbered with snow this weekend, which could do to us next week the same thing it did to us this week and push this jury deliberation out days and days. So, all right, struggling is half the fun. I try hard. So we're going to go to lunch. We're going to play the music. You guys get some lunch. We're going to be back here live with Verdict Watch. We actually already have a portal set up. So all you need to do is click the little, click the like button, which automatically pairs you with a portal buddy. And then you'll just be making the jump automatically over to the new live stream where we'll continue this. We might get to do a little court hopping, which we have not done in a long time. It's a long time. My vote, 2 hours. 2 hours and 10 minutes. That's it. So I'm gonna be with the majority here. But 2 hours and 10 minutes is my deliberation timer. It might be 3:10 if they take an hour lunch. So, but I think we'll get it today. Grab your portal, buddy. It's gonna be nice and smooth. No worries. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again in about. What time did I say we go live? I don't know. Hang on, let me check. Soonish? I said 1:30, so we've got a little over half an hour. I might do 1:45. I'll push it out just a tiny bit. You guys have a good lunch. We will catch you on the other side. If there's a verdict, we'll come back earlier. So just know we're not going to miss anything. And get some food. You deserve it. Get a break. Run to McDonald's. Get some food. So, be good to each other. We'll see you guys on the other side. Bye-bye.